Please, Lordship.
Yes.
And we have already filed a writ appeal. Can it be listed on Friday, man? Man. May I please, Lordship?
Lordship, the consent of others are mailed. I mention item number 7 mailed.
7.
Yesterday, I submitted a adjournment request with consent.
Why do you want an adjournment? It's a matter of 2018.
Lordship, only 2 weeks mailed because the Rasmus one Susan to engage Diganda the senior, but he is out of 6 mailed.
All right. A request is made to adjourn the matter on behalf of the respondent number 1.
Lord.
Because Mr. DJ Das, senior counsel representing the respondent, is not available today. List after 2 weeks as per.
May I please, Lordship? Lordship, I became item number 48, my lord. In this matter, my lord, the arguing counsel.
Can we
from
take it
Mizoram,
page wise, please? Page wise, please.
Lordship, may please, Lordship. Lordship, I beg with the consent of the other side, I beg to mention items 8 to 39, Lordship.
Why?
Lordship, not the learned advocate general appears in this matter. He is not available today, Lordship.
He needs to stay more in Guwahati.
Lordship, if the Lordship may fix it after the 13th of June, Lordship.
What are the matters about?
This is the
Lordship,
validity of Assam entry tax.
Entry tax. The analogous matters are pending in Itanagar.
Well,
Same.
I think that matter is also in the list.
It's already there. Okay. 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 Yes, I suppose we transferred it here.
My it has been transferred.
Yes. All right. A request is made to adjourn the matters on behalf of Learned Advocate General Mr. Saikia, stating that he is not available today. List on 13th June,
Lordship, 14 June, after 13 June, Lordship.
15 June, with a clear understanding that the matters shall not be adjourned any further.
DPO.
My lord, I wish to mention item number 43 to 47, my lord.
Why?
My lord, in this case, my lord, advocate general will appear, my lord.
That's not fair. Advocate General not being in the court for about 15 days. It's totally unacceptable. State will remain undefended for all this period. You yourself put a question to yourself.
My,
Advocate General's absence is being marked for 15 days. These are not holidays for the court. He's a constitutional man, authority. Then
my lord, on 24, my lord, he will be available, my lord.
24th, he'll be here.
My lord.
And these matters were got adjourned on for 13 June.
But he'll be a little irregular till 13, Lordship. Therefore, I made a mention for after 13.
IPL ends on 13th or what?
Lordship.
Anyhow, a request is made to adjourn the matters on behalf of London Advocate General, Mr. Saikia, submitting that he is not available today. List after 2 weeks.
Yes, my lord.
But item number 48, my lord, the engaged counsel is from Mizoram, my lord. Due to some logistical issues, he could not come, my lord. My lord, I request for on his behalf to fix this matter on
48.
2nd.
Mr. Gogoi,
For Mr. Silo, my lord.
Mr. Silo, appearing for Mr. Silo, prays that the matter may be adjourned as the arguing counsel is not able to attend the matter today. List of 2 weeks. Okay.
Well, obligation.
May I please? I wish to mention one retail mallet for listing.
What is the matter about?
Matter with regard to we have challenged the service rule of 2018 with regard to post of recruitment to the post of vice principal of the higher secondary school, my lord. Petitioners are some of the petitioners are going to retire.
Friday. Yes.
My lordship, I beg to mention for listing is tomorrow, my lordship, is urgent.
What is the matter, sir?
It's regarding no confidence motion of our panchayat, my lordship. I took the plea of deemed lost of no confidence, my lordship. It's because the group members appeared in the
All right.
meeting.
Tomorrow.
Deeply obliged.
Item number 1 for fresh admission.
My lord, this case, my lord, by previous order, they are asked to file counter affidavit. That has not been filed, my lord.
Yes.
I'll request on time. I'll pray for a short date, man. Instructions are awaited. And that apart, on the last date or lordship, if I recall correctly, there was an issue. Lordship had expressed his mind since it was this PIL. The ground of grievances they being my lord asked to evict. So my lordship had posed the question to them that whether they are entitled at all, my lord.
In any event, we have asked you to file the affidavits
I need a further time of 10 days, man.
and counsel Mr. So-and-so appearing for the respondents. Praise for it is granted. Further opportunity of 2 weeks
My
to file the counter affidavit.
My-
Deep level.
Deep level.
List of 2 weeks.
Item number 2 with item number 78 of supplementary.
Please, your lordship. Matter relates to re-examination of Knockney, your lordship. The petitioner, he was selected for appointment in the CAPF, lordship.
Elected for?
For appointment in the CAPF as a general duty, lordship.
Yes.
And then physical efficiency test was done and physical standard test was done. He was
Mic,
cleared success.
is your mic working, Mr. Counsel? We can't hear
It
it.
is on, lordship.
All right. Then what happened?
And then lordship will find at page,
Declared unfit in medical examination.
yes, lordship.
So what is the scope of interference in this matter then?
Lordship, the DME, page 62 of the read appeal, lordship. DME was conducted, detailed medical examination was conducted.
Yes.
The manner of conducting, I am challenging the manner of conducting the review medical examination.
What is the scope for the red court to go into that?
Yes, lordship.
Yes.
Your lordship will find the report at page 66, the review medical examination report, which says that I am unfit on account of knock knee.
Knock need.
Yes,
Yes.
lordship.
Yes.
Now, if your lordship read page number 148 for a moment, the manner of conducting the detailed medical examination.
A manner of conducting.
Yes.
Will you challenge it before participating? That no,
lordship.
this manner is not correct.
I'm coming into that. Lordship.
Yes.
Page 148
Hmm.
is how they measure knock knee.
Yes.
And once a candidate is found unfit on account of knock knee, he is directed to file an appeal for review medical examination.
Directed, no, he is given an
Yes.
opportunity to.
Yes,
file.
yes,
Yes.
yes. Now, review medical examination, if your lordship comes at page 168 and page 169, there are guidelines for review medical examination. That guideline has not been followed in this case. lordship.
What guideline? Which part of the guideline has not been followed?
At page 170, lordship, it is specifically mentioned. Clause 3I, for knock knee, bow leg, cubitus valgus and varus deformities, X-ray plate with findings should be attached.
Hmm.
So while conducting review medical examination or review medical examination, that X-ray has to be done. Here, in the detailed medical examination, that wooden scale of 5 centimeters
For-
was used.
Few examples are being cited for guidance.
Yes.
It is not a mandatory requirement.
No.
If by mere looking, the
Yes.
person is knock-kneed, why do you need to go for an
Lordship,
X-ray?
that is why this has been given, because just visual.
These are examples, gentlemen. If by visuals, the person is knock-kneed, you don't need a rocket science for finding out a man is knock-kneed or not.
But by visual impression, we can't say that whether that person is.
You can definitely say that is the very test. What is the distance between the two malleolar bones?
That 0.5.
Yes.
0.5 centimeter.
Not 0.5,
Five
more
centimeter.
than that.
5 centimeter.
Yeah,
but
5.
Yes.
So 5 clear centimeters distance. You
Yes.
don't need an X-ray for doing that. The thin air in between the two knees,
Yes.
that will not get
These are a
detected
few
by the
examples, but
X-ray.
at serial number 2, if your lordship, pair serial number 2, of
Yes.
the guideline, for the defect for which candidate has been declared unfit should be examined thoroughly and the findings must be got supported by proper investigation report.
if applicable.
Yes, it is
If
applicable.
applicable,
That
that's
is
what
why-
we are saying. If by mere vision,
it
the
is
person is found to be knock-kneed. Have you given any contradictory report on it?
Yes, yes.
Let's see your report. Where is it? Gross knock-knee. That is the finding in
At
the
page
medical board.
67, at page 67,
Yes.
I was examined by a private medical center, which certified that,
Why not a government medical center? Why didn't you approach a government medical
yes,
center?
lordship.
Private
At
certificates.
page 69, lordship.
Yes.
I got my X-ray done at
Yes.
Guwahati Medical College and Hospital.
So does it give any opinion regarding knock-knees?
No, lordship.
Then The test is for knock-knees,
Yes,
gentlemen.
yes. In review
All right, let
medical-
us see
Lordship,
how
in-
the single bench dealt with your issues.
Lordship, in review medical examination, one more thing has to be done. If a candidate is found unfit in detailed medical examination, that candidate, if he appears before the review medical examination, there has to be specialist of that concerned field for which he is declared unfit. In my case, there was no
This is-
specialist.
Just by mere vision and physical checking, gentlemen, the distance between the two knees is measured.
In that case, Lordship, tomorrow they may send someone back.
Even a
by
mason
saying
can
that-
do it.
They-
You don't need doctors. Anyhow, let us see the findings, trial court.
Hmm?
Sorry, single bench.
At
Yes.
page-
178. 170.
Para.
The relevant para, your lordship will find at
Page 8 and 9, Lordship.
Yes, read please.
In the quest to understand the tibiofemoral angular, peruse the medical textbook available in the internet named The Measurement and Analysis of Axial Deformity at the Knee, written by so-and-so, Department of Orthopedic Surgery, so-and-so, which is published by Home Striker Center, copyright @ 2008 Striker, wherein at page 10, the tibiofemoral bone diagrams are given and it has been explained that if normal is assumed to be 6° valgus, the deformity is 14° valgus. That is based on
Read
some.
para 9.
Yes, Lordship. Therefore, the RME appears to be in consonance with the X-ray report and the medical certificate issued by the Guwahati Medical College and Hospital. The printout of photograph of the petitioner, which is available in the record produced by the learned CGC appearing for the respondent number so-and-so.
Gentlemen,
It's a
so
prima facie
visual
evidence.
impression.
Lordship, this is just a prima facie visual impression.
Yes.
The visual impression, Lordship, tomorrow, if it is allowed to measure someone with a visual impression.
It has been measured by the board. It has been measured.
Yes.
The review medical
No,
examination.
that review medical board.
Any malafide attributed, please.
Yes, Lordship.
Let us see.
in-
Where is the allegation of malafide? To whom it is attributed? Read, please.
Lordship, may kindly come to page 168.
Yes.
Candidates declared unfit, guideline for review medical examination. How review medical examination?
Oh, we are asking you simple question.
Lordship. In review medical examination, there has to be specialist doctors.
Is there any allegation of malafides against the review medical examination board? If not, they have done an objective exercise. They have found your client to be knock-kneed. That's all. What is the scope of interference?
Lordship, because the guideline prescribes that
Yes, guideline, read guideline.
candidates declared.
Broad conditions.
Yes, Lordship.
Yes.
After completion of review medical board proceeding, the final outcome in consolidated form will be displayed for formation to the candidates on daily basis. Ordinarily, there is no right of appeal against the findings of the recruiting medical officer or initial medical board. But if government are satisfied on the evidence placed before them by the candidate concerned of the possibility of an error of judgment in the decision of the recruiting medical officer or initial medical board, it will be open to them to allow re-examination by the review medical board. If any medical certificate is produced by a candidate as a piece of evidence about the possibility of an error of judgment in the decision of initial medical.
Gentlemen, just give us one answer.
Yes, Lordship.
Why didn't you go to the medical hospital, the government hospital?
Yes,
And
that is
just
there,
hold on, sir,
Lordship.
and ask for a examination of knock-kneed. You just got yourself x-rayed. The knock-kneed report you are producing of a private doctor. Why didn't you ask a government?
Lordship, at page 63,
Yes, read.
page 63.
What you referred to
Page
on our
63,
previous,
this is the form which was given to me by the CRPF, by the respondent authorities.
you
directing-
gave evidence in contradiction
Directing me to.
by
Yes, Lordship.
the certificate which has been produced on record,
Yes.
which you just now read,
Yes.
is of a private doctor.
No, Lordship, this is from the government hospital.
Which certificate?
Page 63, Lordship. This was issued by the ENT specialist, senior medical and health officer, DFU. civil hospital.
ENT.
Yes, no, there are three doctors. I'm.
Oh,
reading
yes.
it. Then Department of Ophthalmologist, DFU Medical College and Hospital. And then Department of Orthopedics. So there were three specialists. They certified that I'm fit for the job, Lordship. And then my review medical examination was conducted, wherein there was no specialist officer of the concerned field.
Annexure 3 was issued by, Annexure F was issued by,
Issued by the Registrar, Department of Orthopedics, DFU Medical College and Hospital, and then Department of Ophthalmology, DFU Medical College and Hospital, Senior Medical and Health Officer, ENT Specialist, DFU Civil Hospital. The DFU Civil Hospital becomes now DFU Medical College and Hospital. Lordship.
oh, gentlemen, read number 2 is a very craftily drafted opinion. Does it give out the distance actually? Read what examination was conducted.
I understand, have the knowledge that so-and-so.
Intracondylar, intramellular distance
Yes.
is within physiological limit and will not cause any impairment in carrying out normal physical activity.
Yes.
What was required was to measure the distance between the mellular bones, which has not been done.
But in review medical examination, they also did not do it, Lordship. That is why I'm praying for a review medical.
All right, okay, yes.
So, my lord, how to determine the knock knee that has already been prescribed under
Prescribed where,
revised
sir?
medical guidelines for medical test.
Yes,
And whatever method that has been incorporated in those guidelines, we have simply followed, and we have simply followed it uniformly to every candidate who comes to us for recruitment.
Hmm.
So there is no question of having any ulterior motive or malafide motive on the
Hmm.
part of the respondent.
yes.
So, my lord, this method has been uniformly applied,
Hmm.
and subsequently he was found to be suffering from knock knee.
Okay. What do you say about this report annexure F? What is your
My lord, my
statement on that?
Page 63.
Page 63. Whether your review medical board has considered this report?
Yes, my lord.
Read.
All these particular medical documents.
What is the opinion regarding this certificate? This certificate was procured by the candidate
Yes, my lord.
in pursuance of your recommendation?
Yes. Page 62, serial number 2, Lordship.
62.
Serial number 2, Lordship.
No, this is a procedure, my lord, to file an appeal, whatever the.
So he gets a medical fitness certificate from a board.
No, he might get a medical fitness certificate for the board.
Then
But,
how,
my lord, all these.
gentlemen, the guidelines say that if the candidate produces any contradictory evidence, then you have to consider it. Where did your board consider this certificate? Read out, please. Whether this certificate was at all produced before the board.
No, my lord, this particular certificate has been considered. It may not be.
Read
specifically
from the
required.
board's opinion, please. Read from the board's opinion that this was considered.
My lord, may kindly come to page 66.
66.
No, this
Yes.
is a report of review medical examination report. Now, basically, my lord, in this case, what has happened when a medical examination has been conducted on this particular candidate, he was found to be unfit for 3 reasons.
Hmm.
First is
Defective color vision,
color vision,
ear
second one
wax.
is hair
Yes.
wax, and
Yes.
third one is gross knee.
Yes.
But in the review medical examination,
Hmm.
he has been cleared from 2 deformities that has been earlier prescribed by
Right.
the detailed medical examination. So there
Understood.
is no partiality, my lord.
That's
And
all
when
right.
There is already a procedure that has been prescribed.
I
in
understand.
the Uniform revised.
Your
guidelines.
guidelines say,
Yes,
did you get our query, please?
yes, ma'am.
That if the contradictory evidence is produced, it has to be considered. Show us from your proceedings that this report was considered.
No, my lord, there are 2 other.
Form number 1.
No, my lord, may kindly come to, just for my satisfaction, page number 66, 67, my lord. This is a report obtained by the appellant himself. My lord, may kindly, this is to certify that the above mentioned patient is examined by me and he is treated normal.
Hmm.
There is no significant Zena vulgar or Zenuverum noted knock knee. My lord, no significant. There is minor knock knee. The appellant is suffering.
Did you
There
get
is
our
no
query,
rare
sir?
aspect.
Did you get our query?
Yes, my lord.
This form number 1 was procured by the candidate on your recommendation.
Yes, my lord.
Did you consider it or not?
My lord, this
There are
particular-
3 doctors and in the review also there are 3 doctors. Which is the orthopedic specialist in the review board? Let us know. Did you have any orthopedic specialists? Who are the members?
My lord, there are 3 members.
All right, the second member, who are the 3 members? What is the specialty? Keep your record available.
My lord, I will.
Original record, officer in charge, counsel representing shall keep the officer in charge present in court with the original record pertaining to the review medical examination of the appellant. List on Monday next. 78 is also connected.
17, I'll address the court. There is,
My lord, I have one request. Can it be on 31st, my lord, instead of Monday? 31st,
31st, all right, 31st.
deeply.
my lord, I had applied for a CAPA post. Advertisement was of 24/1/2015. Whereas, my lord, my eyesight was found to be poor. Then I went on, my lord, to have a medical checkup outside some specialist hospital. They say my eyesight is okay. Then I go for a
Review.
appeal against their findings.
Yes,
And they reject me again saying that, no, your eyesight is bad.
yes.
Then I got tested in 2 other hospitals outside the state also. Whereas, my lord, again, I came before this honorable court. I said, like, I have to,
Is there a procedure of review after review?
my lord, that is why I'm harping on, my lord, because, my lord, advertisement was of 24/1/2015.
Yes.
And on that day, on the date of advertisement, my lord, if my lord goes to guidelines of 2011 were prevailing, my lord.
Yes.
But I was rejected invoking, my lord, guidelines of 2015, which came into force in the month of May.
Maybe the guidelines, these are procedures, they will apply on the date the examination is carried out.
No, my lord, examination was carried out, but my lord, when this advertisement was of January, guidelines came into force in, my lord, these guidelines which rejected me, my lord, they were rejecting me, it came into force
Gentlemen,
in the
these
month
were
of May.
uniformly applied for all candidates.
My lord,
They were uniformly applied for all candidates. How can you claim bias?
Well,
These are
that is-
guidelines. The
that is-
current guidelines will, of course, govern the assessment.
on the date of, my lord, advertisement, this advertisement was silent, but, my lord, which guidelines which came into force in the month of May, which cannot, how it cannot be, can be applied in rejecting a candidate which is selected in
Only
the month
the
of January, my
law,
lord.
only the law which increases the rigor of punishment cannot be retrospective.
My lord.
That is prospective. But these guidelines, since they have reproduced the earlier set of guidelines,
My lord.
the date on which the medical examination is conducted, the guidelines in force on that day, they will be applicable.
This honorable court, my lord, in a few judgments,
Yes.
these kind of judgment, these kind of cases, my lord, they have said, once the game is on, you change the game, rule of the game, my lord. Exactly similar, my lord. I'm
All
facing,
right.
my lord.
Mr. Chaudhary has enlightened us on this aspect quite significantly.
Well.
Don't worry. We'll deal with these judgments. These are not rules of the game, gentlemen. These are means of assessment.
So, my
They are
lord,
not changing any yardsticks. They are not changing any standards which have been set. They simply say that the manner of evaluation will be this. They don't change anything at all.
Since it is, my lord, two double-edged sword, my lord, since it deals with my life.
You know,
my life
gentlemen,
and
let us take one
opportunity,
case.
My lord,
The process was started in 2011.
my lord,
At that time, the candidate was fit.
yes, my lord.
But ultimately, the recruitment, the medical examination takes place 6 years down the line. And the candidate says that I was fit in 2011. How can you disqualify me now?
This
Because
is,
you were
my lord,
late.
The date was, my lord, 2011 to
So
15, my lord.
obviously, the medical examination, which is concurrent to the date, the standard will apply of that day. You can't hark back that the standard which was
So,
applicable.
whereas civilian doctors say my eyesight is okay. Of specialist hospitals, my lord.
Okay.
Well, I pray for a similar, I have a similar.
Not required, not
condition.
required in your case.
I have a prayer.
Yes, what do you say?
My lord, yes, my lord, in the my lord, advertisement of 2015, appointment order issued on my lord, 27/4/2018, my lord, page 128.
128. Appointments have been issued, have been
Provisionally
made.
appointment, provisional appointment.
Yes.
27/4/18, my lord.
Yes,
My lord, may come to page 129, my lord, next page, my lord.
yes.
Here, my lord, Roman 14, my lord.
14, yes.
Here, appointment will be subject to found fit if fresh
Yes.
medical examination to be conducted at the training center if the validity period of 1 year from the date of your initial medical examination would have been elapsed.
Yes.
2015, it was conducted. Now 2018, Malad, as per the advertisement, Malad, in page 55 of the portion of the advertisement, I said better is 6/6. Worse is Malad 6/9. His first medical examination Malad was done subsequently, Malad, page 91.
Just hold on. Page 91. Just hold
91, Malad. This is 15/6/2018 after the appointment.
Just,
Malad.
just hold on. Let's get the document. Yes.
15/6/2018 after the appointment, Malad, page 91. Here, Malad, right eye is 6/9, left eye is 6/9 and 6/6. my lord, may now, then he prefer, my lord, review medical board. It was held, my lord, page 94, my lord, page 94, my lord.
Yes,
Here, my lord, one is, my lord,
both defective,
both defective, my lord. One is 6/9, one is 6/18, my lord.
Yes,
So, my lord, 6/9 is the worst, my lord. Now, my eye is deteriorated, my lord, and question is 6/18. So this
My
is
lord,
review
they have
after a review.
contradictions in their own report, my lord. If going by this logic, my lord, by today I'll be blind, my lord.
maybe,
My lord, page
It may
114,
happen.
my lord, page 114 per moment, my lord. This is a specialist eye hospital, my lord.
Oh, my lord.
It
yes.
says my vision is intact, it's
And-
6/6 perfect.
Here is ophthalmologist, my lord, eye specialist, all, my lord.
All right. Anything else to say, sir?
My lord,
Anything else to add?
yes, my lord.
Yes.
And I got, these are different reports, 91, my lord, it has been not been signed by, my lord, it is, my lord, there are contradiction in 91 and page 94, whereas in 114, my lord, my vision is intact. If going by this logic, it deteriorates every day, my lord. And
Yes,
apart from that, my lord, that only not the year, my lord, the month is relevant. Since, my lord, it was a advertisement was of, my lord, January, I got appointed in month of April, my lord, guidelines, these guidelines upon which I am rejected, but they come into force in the month of May.
okay,
Whereas, my lord, if my lord goes to my affidavit, my lord, at page 169,
yes.
my lord, I have extracted a portion of the 2011 guidelines, my lord.
Mm.
Page 169, my lord, guidelines for review medical boards. In that review, my lord, if my lord sees page 94.
Guideline for review.
Mhm.
169 guideline for review.
Numbers. My lord, findings must be corroborated with confirmatory trace investigation opinion of super specialist of government hospitals, medical college, or government approved private medical centers, my lord.
Which para you are reading?
My lord, page 169, para, at the bottom, my lord, review guidelines for review medical boards. Point number 2, my lord.
Few examples are being cited.
My lord.
That's what you are reading? You're reading few examples,
No, I'm not reading out examples, my lord.
then
This is the
para,
2011
which
guidelines.
para of guidelines?
Paragraph 116, paragraph 2, my lord.
Yes, read.
Review medical board should examine the candidate specifically for the deficiency of which a candidate has been
Hmm.
declared unfit.
Yes,
However, no obvious defects, review medical board may give its opinion. No opinion is given, my lord. Number 2, my lord, for the defect of which candidate has been declared unfit should be examined thoroughly and the finding must be got supported by proper investigation reports. Review medical board should get opinion of other specialists or other super specialists of government medical hospital, college and hospital in case of any controversy.
yes,
It must be kept in mind that the competent medical authority has certified that the candidate is not suffering from the disease for which he has been rejected, making the decision of the earlier medical board controversial. Therefore, in no case the candidate should be rejected by the review medical board on the basis of clinical findings only.
yes,
Findings must be corroborated with confirmatory test / investigation / opinions of specialists / super specialists of government hospitals / medical colleges / government approved private medical centers,
Yes.
my lord.
What have you said in your writ petition? Which part of these guidelines was not followed?
My lord.
Which part of this guideline was not followed
Not part,
as
my
per
lord.
your
It's
writ
not
petition?
followed at all, my lord.
Where
I'm
is your
not saying
plea?
that
read
piecemeal,
your
no, my
plea.
lord. They didn't apply any these guidelines, well. They invoke a separate.
Will you
guideline
please
to-
hold on?
My lord.
We are putting your query.
My-
Where is your pleading, please?
Mhm.
Is it ranting of like anything?
My lord. My lord, grounds at page 11.
Petition.
Appeal.
Writ petition, please.
Nine. That pleading has not been taken, but the civil doctor's opinion has been, my lord, at para 9, my lord. That there's a difference, my lord.
Dismissed.
My lord. Obliged.
This was item number? Yes.
Item number 3 of daily list.
Yes.
But in this case, my lord, today I have, in the morning, I have received the affidavit filed by the respondent, my lord. I need to file the reply, my lord, 10 days time. will grant me my
Counsel,
date.
Mr. For the petitioner submits that he has received the affidavit in a position filed by the respondents today.
Today in the
and-
morning.
And yes, today only we have mentioned, and that he would need time to file an affidavit in reply. Time period for his allowed list of 2 weeks.
Any
How
date,
many times? How many days?
10 days, my lord, after 10 days,
List.
any date, my lord.
List on 14 June.
Obliged, my lord.
Yes. Check that.
Item number 75 of supplementary list for orders.
Mm. What is it for? Service. Mm. Whether the notice has been sent by the office in terms of this earlier direction. Management direction, the other notice shall be forwarded. There is no noting has been issued. Await return of notice issued to the respondent. A reminder be issued to the DG CRPF to transmit back the notice at the earliest list of 2 weeks.
Item number 76.
Yes.
Yes, my lord. Yes.
Mm.
The matter as present is with regard to transfer of the petitioner from his place of posting Akardala to Bunai.
Mm.
In this matter, the petitioner has brought before the respondents on the basis of DOPT order, which is at batch 88.
88.
Yes, for consideration of his transfer, for reconsideration of his transfer order.
Yes. Read,
Yes, no
please.
batch, DOPT at batch 88 says,
Yes.
in Bara 1, my lord,
Mhm.
yes, my lords. In view of the utmost importance attached to the enhancement of women's status in all walks of life, and to enable them to lead a normal family life, as also to ensure the education and welfare of the children, guidelines were issued by DOPT in OM number so and so, dated 3486 and all so and so, for posting of husband and wife who are in the government service at the same station. Department had on 23/8/2004 issued instructions and all like, and so para number 1 and para number 2 is a directive given to the respective departments to give importance to a working woman. Now, in my guess, I have my wife is employed working in the Data Institute of Social Sciences posted here in Guwahati.
Mm.
Although Data Institute of Social Sciences is not a direct, is not a central university per se, but according to section 2 of the UGC rules, which is given in the in page number, my lord, which is given in
Is
just
TISS is not a government service, Mr.
yes, in page number
Is
30.
Council, service in TISS cannot be equated to government service. You can't dispute that.
Yes, my lord.
So how
Otherwise-
does this OM apply to you?
My lord, then, again, on the basis of compassionate appointment also, I have sought for my transfer, which is a policy of the GS, of the Geological Survey of India.
Compassionate
given in
appointment,
Yes.
is this a case of
no, no.
appointment or a posting?
Posting.
Then-
Posting on compassionate grounds, my lord. So
Yes,
it is given in page 119 also, my lord.
yes, please.
Yes, page 119.
Yes.
So in batch 125,
Yes.
yes. this is a policy transfer, and this is a transfer and placement policy of Group A and Group B gazetted officers of Geological Survey of India. I am a Group A employee posted as director at the Geological Survey of India, Agartala.
Yes.
Now in point number 8.0, compassionate postings and transfer, my lords. May I read? Yes. Every officer is expected to serve anywhere in India in public interest, my
Yes.
lord. However, in case it is possible to reasonably make alternative
Possible
arrangements.
to reasonably make.
Yes, reasonably make alternative arrangements within the framework of this policy.
Yes.
Personal circumstances of officers and their families will be given due consideration. For the purpose, the department will endeavor to follow all guidelines.
How long is your client serving here? What is the total duration?
My client has been, yes, I've been serving at Tripura for 5 years. Yes,
So,
my lord.
Does
And so
your
I've
wife is serving at Guwahati
Yes.
and
my-
he is serving at Tripura? So,
Yes.
so what difference does it make that he's sent to Pune or he
Yes,
stays
I
in
have been
Tripura?
transferred to Pune, which is a distance of 3,500
Yes.
kilometers from my
Yes.
place where my family is staying. My wife has recently given birth to a baby.
So you ask your wife to seek transfer to Bombay,
My lord,
which has a center at Bombay also.
my lord, again, in para number 5 para number
Yes,
5 of this,
yes.
in para number 5 of this policy, batch number 123,
Yes.
123. It is specifically written that in para number 5.05.1, may I read, my lords? As per the present TOPT guidelines, there is a fixed tenure of posting of 3 years at a time for officers with service of 10 years or less than 2 years of a time for officers with more than 10 years of service. Periods of leave, training, and tour outside region as in excess of 15 days. All these are policy. 5.2. Person who has completed full tenure in Northeast region will be considered for posting of his choice one time. Now, domiciles of Northeast region will also be considered at par with other officers. So I am a domicile of Northeast region. I've been posted in hard posting according to this transfer policy, which the respondents does not want to consider my representation on this basis, which I have been serving all this for my rainy days in a
Yes.
situation like this when I will be married and when I will have this kind of family circumstances,
Yes.
my lord.
Yes.
Now the respondents, despite all my requests, they have been objecting to this to my representations. Now I have also a Supreme Court judgment with me, my lord, as a reference for your.
Yes, please.
Yes. So this one. Thank you. Yes. This is Supreme Court judgment in Delhi High Court judgment in which a reference of the Supreme Court has been taken in para 24, my lords.
Yes.
Yes, para 24. Para 24, may I read, my lords?
Yes, yes.
Yes, in para 24, in Punjab and Sindh Bank and others versus Turkesh Kunwar, the Supreme Court summarized the principles applicable to transfer orders as under. We must begin our analysis of the rival submissions by adverting to the settled principle that transfer is an exigency of service. An employee cannot have a choice of postings, which is very correct. Administrative circulars and guidelines are indicators. Administrative circulars and guidelines are indicators of the manner in which the transfer policy has to be implemented. However, an administrative circular may not itself confer a vested right, which can be enforceable by a writ of mandamus, unless order of transfer is established to be mala fide or contrary to a statutory provision or has been issued by an authority not competent to order such transfer, my lord.
Yes.
So in my case, the representation as directed by the Honorable Central Administrative Tribunal Guwahati has not been has not taken the concurrence of the Central Ministry of Mines, which as per this order also. So the representation, which the comprehensive representation was directed to be considered by the respondents. Considered by the respondents as per the directions of the Honorable Central Administrative Tribunal, my lord.
Yes.
Which is not for which the respondents, which is the Deputy Director General of the GSI, has not taken the concurrence of the Ministry of Mines, which is given in their own rules again, my lord, in batch number Page number 129, my lord. My lords,
Will you come to page 171?
page number 171, my lords.
Yes.
171. 171. Yes.
Para
my
three.
lords,
Para
171.
3.
Yes,
Hmm.
yes, yes. The the Honorable Central Administrative Tribunal has directed on 9/11/2022, my lord.
Hmm.
And they are saying they have taken the concurrence on 18/10/2022.
Hmm.
It was directed on 9 November 2022, whereas they are showing a backdated decision that was taken earlier. The representation was required to be considered by the respondents, my lord, as per the directions of the Central Administrative Tribunal, which was given on 9/11, my lord. Yes, my lord. So in such circumstances, as per the transfer and order, transfer policy of GSI 2016,
Yes.
I have this right. I have a matter of right to be posted one-time choice posting as per 5.0 of the transfer policy, my lord.
Yes. Yes.
So, the Honorable Central Administrative Tribunal has been given me protection up to 9/12/2023 until the judgment and order of this judgment and order of the Central Administrative Tribunal was passed. Thereafter, I have been issued a relieving order.
Yes.
So, my lord, the balance of convenience lies in my favor as much as this the transfer policy of the Geological Survey of India
No, yes.
2016 is concerned, my lord. So, as an interim measure, during the pendency of this writ petition before my honorable lords, may I kindly be given the protection to be retained at Akatala for the time being, and the matter be directed to the matter be considered for adjudication as soon as possible, so that the department.
We are considering the matter for admission, sir. Let us see
Yes, my lord.
if you can convince us.
Yes,
Let
my
the other
lord.
side have it say. Yes.
Lordship, my only objection is that Lordship, no stay has to be granted, Lordship, because Lordship, in my humble submission, Lordship, my learned friend has pointed out.
We are hearing on argue the admission, gentlemen.
Lordship,
To argue whether it is a fit case for being entertained or not. What arguments he has made? What do you say?
Lordship, it's not a fit case, Lordship, because
Why? Reasons.
Lordship, because this is a transfer order, Lordship. Evidently, Lordship, the OM has no enforceable right, your Lordship, that my learned friend is relying on. And Lordship, kindly come to page 79, your Lordship. This is the order passed after the order of the CAT, Lordship, Honorable CAT.
Yes.
Page
That we have read.
Yes, Lordship. Kindly, this is the order passed by the additional Director General by the Government of India in the head office at Kolkata, Lordship. Can you come to page number 81, Lordship, issue 5. Whether the applicant is discriminated as he claims that his orders badger have been posted with their wife on spouse grounds. Lordship, this is Lordship. There are total 17 officers were transferred.
173. Total, yes.
Yes.
Lordship, by that order, Lordship, the impugn order that he has challenged before the Honorable CAT, Lordship, 17 officers were transferred. Only he has already approached the Honorable challenging the impugn order, Lordship. Only he has approached.
No.
There are
Issue number 5 says 2 directors have moved to CAT and secured stay.
2 directors, yes, Lordship.
Yes. So
Only
maybe one is this gentleman and there might be.
There could be one more, Lordship.
Yes.
So Lordship, the contention of the my learned friend that the order was passed before the concurrence, before the Honorable CAT's order, right? That is not enforceable, Lordship, because this order has been passed subsequent to the CAT's order, Lordship. By
That was not his argument. His argument was that concurrence was taken before the CAT's order. That's what his argument was. Anyhow.
Yes. Moreover, my lords.
Yes. All right. Yes.
My lords. Even after, on the basis of which my learned friend is arguing, there have been given a choice posting to some of my colleagues.
There's no parity in matter of posting, gentlemen. There's no Article 14 in matter of postings.
Yeah, yes, my lord. Anyway, on the basis of transfer and posting policy, I have one-time chance, my lord. So
Yes, thank you.
Lordship,
Dismissed.
the instruction I have received, Lordship, that the release order has been issued, Lordship, in the favor.
That he himself said,
Yes, Lordship. But he
relieving
has
order
not-
has been issued.
That he has not handed over the charge.
All right.
And the
Petition
court has-
dismissed. Thank you. You can take your seat.
also applies, my lord.
Item number 77.
Lordship, here the Guwahati Municipal Corporation has issued a notice, my lord, of demolition and without providing any opportunity of my lord a hearing, which is otherwise the indispensable requirement of the law itself. Section 342 says that prior to issuance of notice, my lord, prior to issuance of any demolition actions, my lord, that notice is indispensable, my lord. That condition has not been followed. Lordship, kindly see page 40. 40A, my lord. There is no any reflection that they have.
Your own case that you constructed it without permission. There are 6.
My lord, the compounding part is there, my lord. If suppose I would apply, my lord, they could consider my prayer, my lord.
Yes.
But my lord, for that ground, my lord, lordship, at least hearing is necessary, my lord. That has nowhere, my lord, reflect.
What do you say, gentlemen?
Lordship, I will appear on behalf of respondent number 3 and 4. They are private respondents.
No, who is appearing for GMC?
So far admission of this appeal is concerned. We will file the.
Just hold on.
Lordship.
GMC,
I am not repeating
Just-
GMC. GMC counsel is here.
you can please allow Mr. Nayak to come. Yes,
Lordship, may kindly see the impugn order, Lord.
yes. The order says that
Page
he has admitted that he has raised construction.
Lordship, it
with a-
was an agreed judgment, Lordship.
No, the agreement was only said, no permission was taken.
No.
But he says,
Paragraph 3, Lordship.
yes, read.
Paragraph
Paragraph
3,
3.
he states, Lordship,
Yes.
petitioner's counsel submits that the petitioner had submitted a letter dated 4/5/2023 to the respondent number 2 to give permission to the petitioner to construct a temporary one-story tin roof study storeroom. He submits that instead of giving any decision on the letter dated 4/5/2023, the impugned letter dated so and so has been issued without giving any notice to the petitioner. He
Yes.
submits that the petition can be disposed of if the respondents take a decision on the petitioner's letter.
All
dated
right,
4/5.
yes, yes. yes.
Next paragraph, Lordship, I have agreed to that proposal, Lordship. Accordingly, the judgment was passed.
Lordship,
Yes.
Lordship, my only prayer is about hearing, my lord. I may be
Gentlemen,
allowed to.
you, that is the hearing which is being given now.
Lordship, GMC authority otherwise passes similar order, my lord. If I would like to place. my
If they pass a
document
similar order, you have a statutory remedy in
there, my
the
lord, but
Municipalities
my
Act.
lord, Lordship,
What is the remedy of appeal?
Lordship,
What is the remedy available in the
my lord, appellate
Municipalities Act?
provision is there, no doubt, my lord. But
Then,
my
all right.
lordship,
Mr. Counsel, will you stop interrupting? We have not put you any query. You have some more anxiety. All right, you come. What is this way of arguing in the High Court? Yes,
Lordship, my
the
only
hearing-
humble prayer.
this is a order obtained by concession.
Absolutely. my
No
lord.
appeal
But,
lies.
Lordship, I have also added a prayer that prior to issuance of any order, I may
Yes.
be allowed to be hard, my lord. That only one line, my lord. I may be hard, my lord. Only that's why I
Mr.
have.
Nayak, you hear him in your representation.
Yeah, my lord. I prayed before the learned singer that I may be allowed to be hard.
When this representation is being considered, you hear him.
Definitely,
Exactly.
Lordship, before, in terms of this order, Lordship, if he wants to appear before the authority will definitely hear him before. passing
All right,
the order.
simple concession,
If, Lordship, if in the meantime, no such order has been passed, Lord.
not a transfer.
No, Lordship.
This
because-
is
Lord,
a
direction.
demolition order.
No, demolition order is already there, but this order was passed on 15th, Lordship, and
Good.
time granted, Lordship, 7 days, Lordship.
Yes.
So that is,
So what is your instruction? Whether any order has been passed on or is it representation? order?
today morning I talked to them, Lordship. They asked me to.
Come back at
wait,
2 and let us know.
Lordship,
If the order has already been passed, he is to file an appeal.
My lord.
Lordship.
If not, then we'll ask your authorities to give him an opportunity.
My lord, otherwise.
One thing he has to admit, Lordship, the building is a very dangerous situation, Lordship, and that is why notice under 434 was issued, Lord.
Demolition,
The
it is-
condition
it is
of the
risk,
building, Lord.
risk to
Yes.
society.
Yes, Lord.
Okay.
That is
Absolutely
why
not, my
notice
lord.
under 434,
Lordship, the
Lordship.
position is that, my lord, on top, I have temporary
And
constructed.
when that
We
is
are
when-
not going into the merits, Mr. Counsel. Come at 2.
Deeply.
Hearing matters will start with that. Parter. हाँ वो लगा नहीं है लगा है बुला लीजिए उनको कॉल मिस कॉल यस
Item number 92 of supplementary list,
Mr. God, yes. Yesterday, we had indicated that we'll be dismissing it, but since the matter had to be restored, that is why it is listed today. And now the fate was already accomplished yesterday. Thank you.
My lord, the in the judgment, yesterday, my lord, in the judgment of Honorable Gujarat High Court, my lord, various judgments of the Honorable Supreme Court has been, my lord, read.
Gentlemen, 23rd April Supreme Court judgment, we gave it to you. You go to DRT, whatever arguments you have to raise, do it there.
My lord,
And then you were given a chance. You were given a lease line. Deposit 50 lakh rupees, you didn't do so. Then that equity jurisdiction goes, no question.
my lord, the only question, my lord, if the notice itself is, my lord, not.
Every jurisdiction is available to the DRT
My lord.
to examine whether the notice is valid or not. Writ jurisdiction is to be excised.
My lord, but the problem is, my lord, before DRT.
Pre-deposit.
Petition has.
Pre-deposit, yes, has
Deposit
to be
the
done.
money also, my lord, that is.
Hmm?
My lord, for approaching DRT, he has to deposit money.
Yes, has to be done. Mandatory pre-deposit is necessary.
My lord.
That is the mechanism provided by law.
My lord.
Writ petition can be filed on 58 rupees 80 paisa. Yes,
But my lord, since the.
thank you. Dismissed. Try and get a better law laid down in Supreme Court. Well, yesterday the council was there. Call him and mark his presence. He is here. He thought that it was decided yesterday. Okay. Yes.
Item number 79 to 91, ordered matters.
Mr. K.N. Chaudhary. Probably Mr. R.K.D. Chaudhary will run out of steam today.
Well, I had few matters. I don't know if it continues, perhaps maybe difficult.
This matter is likely to continue at least for today. Yes. Yes. So you can take a suitable date if you want,
Okay.
or you can wait if the matter gets over. We can call out your cases also.
Well, we'll give the date to the.
You give the date. Yes. Mr. Chaudhary, during the course of today or tomorrow, we need you to place on record with a proper forwarding letter all charge sheets which you have filed in relation to these allegations through CBI. You are the deputy SGI, you are also representing the CBI. Whatever charge sheets you have filed, you have to place on record. You see, there is a very peculiar situation. The charge sheet which we received yesterday.
Yes.
Just hold on. Let us see where are those charge sheets. Now that charge sheet we had yesterday. It's a very interesting issue that you allege that these three contractors, they conspired with RH Khan and Karuna Saikia and indulged in fabricating work orders, procuring fabricated work orders, gave higher rates. You don't charge them for these offenses in this case, and you don't charge sheet them in the CBI case. What does it mean?
One has been let off.
We don't know because this charge sheet which has been presented to us is probably in relation to NIA 2. So where is the charge sheet corresponding, the CBI charge sheet pertaining to NIA 1. Where is the charge sheet?
I'll try to bring it on.
Yes, because the reference which has been made to CBI, read 3B, first page. Was obtained. This is not a certified copy. The photo state of certified. We need certified on record. We'll ask Mr. R.K. Chaudhary to file it. Read page 3, please. These are both charge sheets, yes, 7 and 11. So read the FIR first, Mr. Chaudhary. Page 3. Uh, 3B. Page, there is a pagination on top. All right. So pro forma for making reference. The FIR was lodged by so and so. 2 persons were traveling in the vehicles, were found in possession of 1 crore in cash. So this is as a consequence. No, 1 crore. So this is the reference is as a consequence of NIA 1. Okay. Justification for referring the matter to CBI. Involvement of public servants in so and so and their criminal misconduct. Forgery, etc. was revealed during investigation by NIA. Defalcation of government funds. Conspiracy. Everything. All these facts are there. Funds pocketed by council members so and so. PWD Jayanta Ghosh. Agriculture Department, DRD. So everything is there. And then the charge sheet you file. There are 2 charge sheets. One more Mr. Borgoin has given today. That is 11.
Charge sheet 11, yes.
That is against Mohit Ojai, Arich Khan, Debashish, BC Day, Hamzad Hussain. Hamzad Hussain.
Page 51.
And not charge sheeted Jayanta Ghosh.
Jayanta Ghosh.
Not charge sheeted Sudeep. Sandeep Ghosh.
Sandeep.
So they are not charge sheeted. So what is the impact of that? So that angle of conspiracy between Arich Khan and Jayanta Mukherjee.
That goes down.
Now this Debashish, the charge sheet is in relation to some other order, blankets. Mr. Borgoin.
My lord.
Is there any finding regarding mark trading in this charge sheet? Doesn't seem so.
CBI, my lord,
Yes,
smart trading of finding as a CBI. There's no finding, my lord.
no finding.
I had a yesterday when your lordship has raised this query with respect to double jeopardy and my lord, I was doing a research. My lord, I will put this point. I have got a different view in this issue, which your lordship is taking. So let my friend.
Yes,
raise my
let him,
voice and then I will come up with
let him
my lord.
argue his case, then we will see. These are all altogether different activities which are covered by the CBI. Okay. Yes, Mr. Chaudhary. Let's.
Lordship, accused six, Lordship, urging the
Yes,
Warisa, Lordship.
yes, yes.
Uh, To establish Lordship, his point, Lordship, I would take your Lordship to PW 26, which your Lordship will find at page 135.
PW 26. Then I will. Yes.
I take your Lordship to page 136,
Yes.
the first paragraph.
136.
Again on 1/6/2009.
Sudhakar Singh, you're reading.
Yes, yes, Lordship. Earlier, this PW was referred to, Lordship, but this paragraph was.
You are reading para,
Uh,
page
136, the first paragraph. Pertains to
yes.
Arsing the Warisa.
Mm.
Again on 1/6/2009, I, along with two inspectors and a constable, flew to Bangalore on the order of higher authorities under the supervision of the then DIG, GP Singh. And after reaching Bangalore, we were given information that Mr. Joel Galosa, he was a CNC of DHDJ, an armed outfit of Dima Hasau, was staying in a locality in Bangalore. The area was surveyed with the help of Bangalore police, and he was apprehended with one Partho Varisa. Partho Varisa is alias Arsing the
Varisa. Yes.
and Samir Ahmed.
Mm.
Joel was apprehended in the gym and Partho Varisa was apprehended from a flat where both Joel and Partho used to stay together, and on spot information, they divulged that they were helped by one Samir Ahmed for their stay at Bangalore. And in that way, he was apprehended from his flat nearby. All the three persons were produced in the court of the Metropolitan Magistrate, Bangalore. Honorable Magistrate was kind enough to transit warrant. So, the Lordship, this Partho Varisa and Joel Galosa were staying in the same flat from this witness. Now, Lordship,
In what capacity did you bring them to take them through the magistrate's court? In what capacity? What were they for this witness? They were accused, witnesses, suspects. What were they?
Lordship, in fact, that has not come.
Did he arrest them? Where is the arrest memo? If there has been ever a sloppy trial in this country, This is the ultimate pinnacle of it. Who was to prove it? He is the person
Yes,
who had gone to apprehend them.
yes, yes.
He doesn't prove the arrest memo. The public prosecutor is sleeping. Maybe some inspector might have proved it. Read. You'll be able to find it. Who other inspectors were with this man? But he was the leader of the team. He's supposed to say that they were arrested. And his ipsy dixit that they were staying in the same flat. From where does he get that? And Mr. Chaudhary, I'd like to ask you one question. He was your main culprit, right?
Lordship. No,
Did any one of your officers say that we interrogated this accused? Record that post-dated one disclosure of Banlal Channa and claim glory on the basis of that fabricated recovery. You don't even interrogate your star accused. Or your investigating officers were too afraid of his caliber as the DSDG leader that they didn't dare interrogate him or what? This is NIA. Doesn't say a word that we interrogated them, we got this information. What was the follow-up action? You were just trying to do an eyewash. The entire case, what we could see. Neither any interrogation from this. Where is the investigation from Joel Garlosa? Interrogation. What you were doing of this 1 crore? Who asks him? The disclosure could have led you to some more findings.
Lordship, it is not.
All right. Normally, the court would not allow the disclosure to be brought on record unless it led to some discovery.
It has
But
to lead
at
to
least
some
you had to
investigation.
say that we interrogated this man.
It has to lead to some investigation. Lordship. Yes.
They divulged that they were held by one Mr. Samir Ahmad. Where is that divulging statement? All right, carry on. Then next, who are the other two inspectors who went there to Bangalore? Mr. Burgoyne.
The PW 38, Sukma Puragwai.
PW 38.
PW 38.
Let's read his statement.
Lordship will find that at 294
294.
in volume 2.
Two, 394.
294.
Yes.
On 31/5/2009, the Director General of Police Assam issued an order that I was to accompany the GP Singh so and so to Bangalore, along with additional SP Sudhakar Singh, additional SP City Inspector
Bhupender Kumar Nath has also been examined. Bhupender Nath.
Yes, it's been examined as PW 124.
Yes, all right. All right, read.
Constable G. Chetri, and that we were to work under the supervision of GP Singh and local police of Bangalore. Accordingly, the team proceeded to Bangalore on 1/6/2009 by air. On reaching Bangalore, we were briefed by the DIG CWR that wanted accused, namely Joel Galosa, a DHD member in connection with Assista PS case number 170 of 9, is taking shelter at Bangalore. And we were to apprehend a said DHD member, namely Joel Galosa, who was pulled up in Bangalore. On 1/3/2009, we were along with local crime branch police of Bangalore proceeded to Arcade, where we apprehended Joel Galosa in a gym.
Come to 293. They were formally arrested on 290 on 4th June. But the recovery which was made on 1st June. Yes. It is now you have proved, your officers have proved 3 days of illegal detention. How we will tell you? Though it was not argued, how we will tell you? They were apprehended on which date? 1st June, right?
On 3rd June.
Apprehended on 3rd June.
3rd June.
Where is it said?
Lordship,
Where is it stated?
Second paragraph, Lordship,
Of
294.
Once.
On 1st.
On 3rd June.
On
Yes.
On 3rd June.
Yes. All right. So you apprehended Joel Carlosa, you recorded his statement, everything. And read page 297, bottom 3 lines.
At the time of arrest of the said accused persons, I prepared the arrest memo for the arrest of the said 3 accused on 4/6.
4/6.
4/6.
So they were not shown arrested on 3rd June.
Lordship.
So all the recoveries which you made were made while the accused were in illegal detention. Which is the 3rd inspector, PW 124. Let's read him also.
Yes, Lordship.
124 page
622.
622. You know this.
Page 622, Lordship.
Sudhakar Singh doesn't say any date. On what date? And very interestingly, the leader of the team, Sudhakar Singh, doesn't utter a word that anything was recovered from the flat. What a brilliant kind of examination was got done. 622. 2. Read, please.
In the year 2009, I was working as inspector of Police Special Operation Unit. On 31st May, the Director General of Police, Assam, ordered me to go to Bangalore to be headed by DIG Soso, GPC, and a team comprising of 5 police officers, including me. On 1st June 2009, we proceeded to Bangalore by flight and reached Bangalore on the same day. On 3rd June,
None of the witnesses.
we nabbed Joel Galosa, who was the chief of DSTJ, in a gym, and Partha Varisa and Samir Ahmed were apprehended in residential building. All were arrested in connection with this again.
Documents.
Police station name is different, Lordship.
Fatah Seal.
It should have been Vasistha.
Yes, Chaudhary, when were they arrested?
It transfers on 3rd, Lordship, from the
3rd, 4th, 5th. Let us see the document of their arrest. Which is the arrest memo exhibit? Yes.
It's not
Not exhibited, ma'am.
Did you put this SP to notice that how you had apprehended an accused without preparing an arrest memo? What kind of investigation were you doing? How do you prove these recoveries now? The accused, if at all you had detained him, they were not arrested. How do you link them with the recoveries? Who says so? Learned special public prosecutor. Gentlemen, your inspector says we apprehended them on 3rd. The recoveries are of 3rd. The arrest memo was prepared on 4th. It was a case of illegal detention. For all we know, they might not be even with you. Who knows? Where are the documents of transit remand? That NIA could have procured. That was not dependent on the local police. The court was there at Bangalore or not? Why didn't NIA get those documents? The transit remand order. Can't say. You were leading the trial. You got examined Sudhakar Singh. Does Sudhakar Singh say a word that any incriminating recoveries were made? He was a team leader. Why didn't you prove the seizure memo through Sudhakar Singh? Anyhow, whatever. 110. Let us see the documents. Exhibit 110. 104 and 110. Page. Exhibits page. Sure.
Exhibit 636.
These are memos do not give signatures of accused.
636, Lordship, volume 3.
Hmm. 104. Read. Ms. Chaudhary,
Yes,
will you please read this.
Uh, 5.
636. Page.
636.
Yes, please read.
I'm reading column 5, Lordship. 7 members of money deposit slip of State Bank, 26 numbers of passport of Jewel Girl, 1 account pay check, 1 driving license issued from the electronic city so and so in the name of Devojit Sinha.
All right. You mentioned so many things.
Yes,
You mentioned so many things, right?
Lordship.
Where are the signatures of the accused? Yes, sir.
Lordship, the signatures are not taken.
Not taken. So there is no arrest memos showing that the accused were in your custody on 3rd June. How do you read these recoveries against them, gentlemen? Please try to tell us. The memos do not bear their signatures. Come to page 651 also. 110. 650, the list starts
Yes, Lordship.
and
This
mm,
only witnesses are there, Lordship, and that's also without date.
Sudhakar Singh doesn't sign it.
No,
And the two witnesses, have they been produced? This Madhav Das and Jilli Balasumatari, have they been examined?
no.
No. Okay. So now please tell us, how do we read these recoveries against the accused?
Paragraph. Yeah, paragraph.
Who cross-examined on behalf of Joel Garlosa? Mr. Burgoyne,
My lord, I did. I did.
did you put him a question that where are the signatures of the accused in this?
My lord, I know. I know. With the passing of the same thing with goes that one which your lordship has said. With passing of time one get wiser. I do. Yeah.
Trial is a very sensitive,
My lord, I do.
you know, standing here and arguing in the high court.
Trial is the main thing, my lord.
Is nothing,
No.
nothing.
Trial is the main thing. I do understand, my lord.
The true intelligence of a lawyer
Comes out in trial.
is tested in the trial.
Trial.
Lordship, I. The
Even if
officer
he
has-
did not, he need,
On the
you know, Mr. Chaudhary, in retrospect, his step of not putting that question might have been, would be treated to be justified because your witness did not utter a single word. Your document doesn't say. So why he needs to put a question?
That is, he.
That would have been to test the credibility. Gentlemen, you say, you attribute this to the accused, show us when he was arrested, show us where are his signatures. And the witness probably would have started asking water in the court.
This is the most primary thing in a cross lordship. I will not say.
Speaking from my experiences, I'll tell you, the witnesses fainted in cross-examination when their lies were caught.
I do not know, Lordship, but I have done a few civil matters. I can see that, Lordship.
All right. Okay.
So 39%.
Yes.
Lordship, the trial court has relied upon PW 39, Lordship, but I will not take your Lordship to that. I did not find it.
You might be more exposed.
No, Lordship. I do not.
It's okay.
No,
Just on the lighter
Lordship,
vein.
take 39.
Yes. No.
Three.
Yeah, just on the lighter vein. Don't take it to your heart.
No,
You can only try to make amends for what has been done.
Lordship, whatever is there on record, only I can.
You.
But I do not see any substantial
Please,
in,
no.
in 39.
All right. Who is PL 39?
It's Sahabuddin
Shabuddin.
at 301.
Just a cursory kind of
Yes.
touch his statement.
Yeah.
What his statement is about.
At Lordship is page 301.
Disclosure statement.
Lordship, volume 3, Lordship,
Now we are having it.
deposition
Yes.
at 301.
Hotel, stayed at hotel.
He stayed at a hotel, but that does not make out.
What,
anything,
how does it make an incriminating piece of
That
evidence?
does not make out.
Yes.
anything, Lordship. And the trial court relies upon PW 66. That's what is it? Lordship will find at page 451.
Nishit Arman.
May I read it, Lordship?
Yes.
I'm coming from the second paragraph. In the month of February 2009, accused Partha Varisa and alias so-and-so told me over phone that somebody will give some cash to him and he should collect the same and deposit in his account. He also told me that the said person will telephone me and tell me where he would hand over the money. The said person thereafter telephoned me and then I told him to come to my place. The said person thereafter came to my place and handed over rupees 3 lakh. On the next day, I deposited the amount in the account of Partha Varisa. Thereafter, also after about 4 or 5 days, another person came to my house and handed over rupees 3 lakhs, and accordingly, I deposited the amount in Partha Varisa's account of Partha Varisa. Thereafter, also after a week, some other person came to my house and gave me rupees 2 lakhs or more, and I deposited the said amount in the account of Partha Varisa. I also paid an amount of rupees 1,60,000 to Tata Motors as payment of loan of Partha Varisa. I further deposited an amount of rupees 40,000 in the account of Partha Varisa. So here, Lordship, in cross, it transpires that the amount which was being given was coming from the
Is stone crushing business.
Stone crushing business. And I would take your Lordship to how it has been dealt with.
One 193.
Can we have it spiral bound? Because all markings are there in this judgment. इसका spiral binding करा दीजिए. ये पहले हुआ बात. Yes. थोड़ा लूज करवाना. जजमेंट
I-
से करना, नीचे का ही अलग कटा दे। इसमें क्या 2 जजमेंट आए हुए हैं, एक नीचे अलग है, एक ऊपर अलग, तो ऊपर वाला अलग से करा दीजिए। यस,
I take your lordship to paragraph 192(1) of the judgment.
yes,
I take your lordship to paragraph 192(1).
yes.
Lordship will find at page 131 of the judgment. It is elicited in cross-examination that the money which has been paid by him, paid to him by those persons under instruction of his cousin, namely Partha Varisa, the money belongs to stone crushing chips, which were brought from his cousin brother, namely Partha Varisa, stone crushing firm. The name of the firm is Arsingda Stone Crusher. Next paragraph. What is transpired from the evidence of this witness is that the handing over of the sums and depositing thereof in the account of the accused is admitted, though it is elicited in the cross-examination of this witness.
Account statement was proved,
Account statement was
proved. Mr. Morgan,
No, my lord. It was been discarded by the trial court because of section 2 of the banker's book.
It's only, I would say,
and this is putting the cart before the horse.
so
Why should they have cross-examined the witness, gained something? You wanted to discredit him. You are required to cross-examine.
it's on lordship on inference that lordship, if your lordship will see.
No, carry on.
192,
Continue.
Lordship.
Not clarified where the firm is situated.
Lordship,
So who was to seek this clarification, gentlemen?
lordship from our side is required to be done. And if it is in half
How
long,
long or conjectural, totally
Lordship,
conjectural.
so far as this witness is concerned, lordship, merely on inference, lordship.
May
Merely on inference, lordship. Because he
has given evidence, continues completely destroying your case against Varisa. Because all he has said, all transactions were valid money transactions as consideration towards stone chips
lordship.
supplied. In the next para itself, he proves this account statement. But the account statement is relating to October 2007 to 15/6.
2009. Admittedly, it was in the name of Varisa lordship. But then,
Yes, the
that
trial
was
court
not-
has discarded it at end of para 193.
Yes, lordship.
Learned counsel has submitted during argument that the above statement is not submitted
Not
as per section 2 so and so. The submission is considered in light of facts, and we find that there is every reason to record concurrence with this submission. So the statement was not accepted.
That was not accepted.
Then, so deposit of these amounts,
Lordship.
not
And I had 146. Lordship, I think your lordship to PW 146 at 686,
Swayam Prakash Pani. Page?
686.
Yes.
This has been referred to earlier. May I read lordship,
Wherever you want to,
Yes.
man.
lordship, the second paragraph of
Yes.
686. So far as this accused is concerned, lordship.
Mhm.
In the instant case, I was assisting CIO Mukesh Singh, then superintendent of police. I was also superintendent of police at that point of time, that is 2009. This was the first case of NIA, which was registered after creation of NIA. During investigation, I was assigned a task, certain tasks related to investigation. I had undergone training on computer relating to the document handling at NCRB, which covers courses and so and so. I had prepared a disclosure memo pertaining to accused Arisho Warisa related to his 4 email IDs, that is, these 4 emails are there with the password, in the presence of witnesses at SOU Police Station, Assam, on 13/7/2009. Exhibit 117. Consequently, in the disclosure memo, exhibit 1173 is my signature. All these mails were attempted to be opened on 24/8/2009 in New Delhi in presence of
Ms. Chaudhary, before we go any further, how did Arshinder Warisa land up in SOU police station on 13/7? Did you take him on production warrant?
Worship. He was brought back
He was brought from where?
Bangalore.
4th June, 5th June.
Yes.
Outer limit for police custody is 15 days.
Losh.
So you can presume that there have been many bunglings, but this could not have been done that he was in police custody for 1 month, more than 1 month and 8 days, 9 days, whatever it is. 3rd or 4th June, you say is his arrest. So could he have been in police custody on 13th July? The trial court tries to read in this date as 13th June, but simply because the prosecutor showed him a diary. So we should ignore the date mentioned in 117 on the basis of, let us see 117 page.
That
Page
is
660,
that
my
is
lord.
fine on 7. That is on 7. Lordship is
Then now, let us still see that information, because that will give one more indication about the credibility of your investigation. Then exhibit
660.
660. We are having it. 660. Yes. How did you get the signature? Was this interrogation? Your IO says interrogation in SOU police station. How was this managed? This was NIA, we suppose. Of course. Yes. How was this signature procured? You showed one diary to the court, trying to change the date to 13/6. But gentlemen, how? Yes. There is a the disclosure memo was prepared by me on 13th July 2009. There is not even 7 JULY is mentioned. Read 660. Read. So how are we to read this as JUNE instead of JULY? And then there was a cross-examination by defense that he was in judicial custody. Did you make any attempt to clarify the thing in your re-examination? Check it up from where? Also, you could have requested the trial court to defer the examination. Presenting the case diary during arguments. This is a mistake, sir. How do you read JULY as JUNE? There's not even a date written that 6 can be read, 7 can be read as 6. It's not in numericals. It's an alphabet. Yes, Mr. Chaudhary. So disclosure statement. What do we do about that? And then a memorandum is not a substantive piece of evidence. What was stated by the accused to the IO? Where do we get it from? He admits very clearly 689, or rather he denies. It is not a fact that the accused was not in police custody on 13 July. So a specific suggestion is given. With due respect to your public prosecutor, he was sleeping when this cross-examination was going on. Either he was not there or he was sleeping. That was a point where clarification was essential.
The last few lines in 6.
Yes. Even though the defense need not have put this question, but yes, still they took that risk. And what explanation could this man give? JULY. Okay, very well.
How the trial court deals with it, Lordship, I'll take the Lordship to paragraph
That we distinctly recollect.
196.
Case diary.
The case diary is 198. So far
Read,
as
read.
this, I'll read from 1.
Yes, yes.
Lordship. PW 146, Sir Prakash Pani testified that he was assisted by CIO Mukesh Singh. In the case, he prepared the disclosure memo, that is 117, pertaining to.
This is another self-contradictory finding.
Lordship.
One place he says that no 67 5B.
That again.
But the fact remained
But
on basis of disclosure statement made by him. But the fact remains. All ifs and buts.
And that is the finding in the next page at serial number 2. So far as Lordship, the date is concerned, Lordship has already taken note 198.1.
Yes.
In fact, the case diary was referred to clarify the date. And Lordship, so far as this witness is concerned, Lordship, this accused is concerned, Lordship, I find only these EWs which the learned court below has.
So
referred
the
to.
inference that Archandra Variso was involved with DSDJ is based only on the fact of recovery of certain email addresses. Other than that, no witness has come in the box saying that this man is involved
No.
with the DSDJ. It's a fact. Okay.
Other accused are already taken your lordship to the PWs.
Yes.
Now, the query, one query has fallen from your lordship regarding the sanction, which I had. Sanction. 8. Section 8. Har kitab. Can I?
Yes.
Section.
Page,
Now,
section 45 it was.
45 of the UAP Act.
UP Act.
lordship.
Yes.
Now this, insofar as sanction is concerned, lordship, it is not the case of the appellants that the sanction was not on time. Rather, it is the case of the appellants that it was too early.
Total non-application of mine. That is what the argument is.
That was the argument.
Yes.
But here is a case, lordship, as it is there.
And one more argument.
Yes.
That as a matter of fact, the sanctioning authority was never examined, so sanction is not proved.
Lordship.
That is a significant argument.
Lordship.
So deal with that.
Lordship.
Where is the finding of the trial court on that? That sanctioning authority, how the sanction has to be proved? Yes. Yes.
Matters dealt with, lordship, paragraph 9.
There are 9.
9 2B.
9 to be. Let's see. Yes.
That is only the first. Uh, 2A. It starts from 9 2A. May I read it, lordship?
Yes.
Next, it is submitted that the sanction for prosecution of the accused persons contemplated under section 45 of the UAP Act is vague and nothing is mentioned in the order. What are the documents considered by the authority while according sanction? And thereby the accused becomes prejudiced. The prosecution side has exhibited the prosecution sanction of accused Karuna Sakya is exhibit 281 and the rest of the accused is 301. The prosecution side has examined 2 witnesses, 75 and prosecution witness 88 to prove the orders. That's the C75. 75 Lordship will find in volume 2, page 473.
Broken. So the thread is broken. Try please for the timing. Page 473.
Sorry, told you it was like
RVS money.
No. Virendra Kumar.
Viren. Yes.
In 2010, I was working as Under Secretary in the Ministry of Home Affairs. I remained in the post till November 2011. Thereafter, I was transferred to the Ministry of Defense, where I am working as Deputy Financial Advisor. When I was working as Under Secretary in the Ministry of Home Affairs, I received a request from the NIA along with a report, as well as gathered materials by them for seeking permission in connection with crime number 2 of 2009. A sanction for prosecution of the central government for prosecuting 16 accused persons, so and so. All these accused persons were charged under different sections of UAP Act and IPC and Arms Act. Thereafter, the materials as well as reports collected by the NIA was sent to the authority so constituted for the purpose for making an independent review of the evidence gathered in the course of investigation in terms of section 45(2) of the UAP Act and the unlawful activities prevention, recommendation, and sanction of prosecution rules. The authority has thereafter, after being satisfied on the materials available on record, on the facts and circumstances stated there, recommended sanction for prosecution. After examination of the materials, records, and sanction of the authority were placed before the HOD, that is a Union Home Minister, and after getting the approval, the sanction was accorded under my signature for prosecuting the aforesaid accused. Exhibit 280 is the sanction order
on the phone and going out.
dated 12/10/2010. And
The
exhibit
council group caller.
281 is my signature.
Talking on the phone and going out. What's this? Court proceeding or what? This nonsense. Find out who was that. Yes.
Third paragraph. When I was working as the Undersecretary in the Ministry of Home Affairs, New Delhi, I also received a request from the NIA along with a report, as well as gathered materials by them for seeking permission in connection with the crime number 1, 2000 sanction for prosecution of the central government for prosecuting the accused Karuna Saitya under different sections of the UAP Act. Karuna Saitya lordship perhaps will not be necessary. Is no longer there. And PW 88 lordship will find total
510.
510. In the year 2009, I was posted as Undersecretary in the Internal Security Division of Ministry of Home Affairs in June 2009. Central government, in exercise of under 65 of the NIA Act, directed the NIA to investigate the case against the activities of Rima Halam Dauga. Accordingly, the NIA has registered its case number as crime case number 1 under 120B, 121, that's all, and 25(1)(b) (a) of the Arms Act. During the investigation, NIA presented the papers to the ministry relating to crime number 1, and the papers were marked to me as per the procedure for examining the grant of prosecution sanction as per the laid down procedure of the ministry. Accordingly, in compliance with the procedure, I refer the papers which inter alia contained the evidence gathered by the NIA to the review committee for their opinion. The review committee consisted of one former law secretary in the government of India and one former judge of the High Court. The review committee's opinion was received and put up to the competent authority for grant of sanction in this case, which is a Union Home Minister. Upon receiving the approval of the Union Home Minister, I issued the prosecution sanction against so and so. Therefore, Lordship, it has been referred for a review to a committee, and only after the committee has examined it, a sanction was accorded by the competent authority, Lordship. Therefore, and the sanction is required only to take the cognizance of the office to go forward with the case, Lordship. Therefore, in my humble submission, when the sanction is there, it is not had it been a stage of belated sanction, there might have been something to do with it.
Okay.
And the latest Lordship discussion which I find on sanction is a decision of the Supreme Court on it's not yet reported, 1/5/2023 in the case of Jasbir Singh. But this was a case for bail, but some Lordship discussion has been made.
Right.
I will give a copy.
What is the ratio? At least mention that.
Punjab Haryana nahi? Punjab Haryana nahi?
No, NI.
NI Punjab Haryana.
No, just Singh, that's it. It says it's not an idle formality, that it has to be, the entire records have to be placed before the sanctioning authority, including the FIR disclosure statement. Not in that procedure.
All right.
This criminal appeal 1011. And last Lordship, this matter being taken up by the CBI. Hey, CBI touch. How much Lordship? Lordship, both the cases, Lordship, so far as the NIA case is concerned and the CPI case is concerned, my humble submission before your Lordship would be, both would be standing on a different footing, because the NIA, if I may say so, was trying to link it with raising funds for and terrorism. And here is Lordship case. So far as the CPI is concerned, it has to be distinguished, because terrorism is one part, and here it is not related with terrorism. It is simply those sections relating to the PC Act and the IPC. Therefore, Lordship, although the Lordship subject of investigation would be same, the consequences would be different in both the cases, Lordship.
Done. Okay, yes. All right. Yes, you want to add something, please come from this side. Yes. What's your good name? What's the name of prosecutor? Yes.
Wait to the Lordship. With all this, I'm not repeating, my lord, what my friend has put on record. Firstly, your Lordship has already gone through.
Okay. Yes.
Your Lordship has already gone through the evidences, and Lordship knows the name as well as the what they have said. So, I'll just take few moments, madam.
We'll put your query. You first satisfy us on that query. Then whatever you want to say, you say. Just hold on, Mr. Satyanarayan. You are Mr. Satyanarayan. No.
DK Das.
DK Das. So, Mr. Das, one simple query, the entire foundation of your case. Terrorist organization DSTJ. Joel Garlosa, its leader, and involved in terrorist activities. Second question, all right, figuratively speaking, or for the moment we may agree that there is evidence that he was the leader. Okay. First question, terrorist organization. And the third question, terrorist activities. What is your evidence on that?
Hello. What has happened, my lord?
Substantive evidence.
I'll just taking your Lordship to the evidence, my lord. What has happened, my lord? In the evidence of Dipulal Hodai, it has come that he was CEM, Chief Executive Member, up to 26/11/08. Thereafter, my lord, there was a meeting. He has gone hostile because only some part of this he has admitted that your Lordship will just recollect. Now, what has happened? After he has given his resignation, he said that due to my health down that I have resigned. Anyway, in the clause of R.S. Khan, your Lordship would remember, he said that I have come to Guwahati for education of my children, the two parts. Now, leaving aside that, my lord, what has happened after accused number 3, Mohit Hazai, assuming the post of CEM, he came to Kuala Lumpur along with PW23 Kulendra Tolakapu.
Okay. Yes. And they were talking about elections.
Now, PW23, he said that we stayed there for 2-3 days, and I was talking to Niranjan Hojai about the affairs of the NC hearings.
All right.
Your Lordship will just my submission is that who is Niranjan Hojai, with whom an executive member and CM, because he said that CM was sitting all the time in a hotel.
Yes.
Let us accept as it is. That he was talking with Niranjan Hojai about the affairs of NC hearings. That your Lordship will just kindly take it off. Because who is he to discuss about here? Unless he is an important person. No.
He's a resident of Aflong.
He's the head of the person, my lord. a commander in chief, my lord. Now, immediately after returning from Kuala Lumpur, incident of Dian Muk, that is Dian Muk murder, case number 2 murder, that happened in February. Just taking up money about 30 lakhs and all. And that was all. Now, on 1/4, your lordship has already gone. This happened about what? Now, your just an important point your lordship will kindly just know. After, I'm not going in details, after they were caught with 1/4. Rajendra, he has denied, but Babul Kamprai, case number 2, he said in his 313 statement, yes, a huge amount of currency was found in Tata Sumo number 12, where I was going.
All right.
No.
He might have a thought of laying a claim to the currency. It's quite possible.
There, your lordship will kindly see one part, my lord, that he admitted of currency note, but he did not say for what purpose this amount he was.
He didn't say, all right, charge 30% income tax and penalty, return the remaining to him.
Yeah, that will come up. There, I would like to praise 106 of the Evidence Act. 106.
Yes, for what offense? Just hold on, sir. 106 for what offense?
Specifically, because it has come in the evidence of, I think, Sodhagar.
Just wait a minute.
This amount.
Wait a minute, Mr. Das.
This amount.
Wait a minute, please. How do you link Hossein Rojai with that cash?
I'm coming to that. I'm coming to that.
All right, you will come to that later. Now you said 106. What? You will just hold on.
Yes.
We are into a dialogue. Please listen to me. Please wait. Babul Kemprai admits in his 313 that yes, there was a recovery. Okay. You say 106. 106 to draw inference of what offense?
No. The link is that, my lord, Tata Sumo was following Scorpio, where.
What was the distance? How many meters? How many kilometers?
No,
what was the time gap?
There are more to it, my lord. There are more to it.
Yes.
Following the Scorpio.
Just hold on.
Scorpio.
Hold on, sir. Please. Who says what was the sequence in which the vehicles were traveling? Let us know. From where do you get? Scorpio was following Tata Sumo or Tata Sumo was following Scorpio?
That is 313 statement of Babul Kamprai.
Mr. Das, please. Prosecution has to stand on its own legs. It's the cardinal principle of a criminal case. As per you, that is the prosecution.
Yeah.
What was the sequence in which the two vehicles were traveling?
In addition to that, my lord.
First, give answer to that question, please. What was the sequence in which the two vehicles were traveling? Yes.
Yes. Your lordship will kindly remember, again, without taking your lordship will to the evidence, my lord, that that Lama, my lord.
Suraj Lama.
We'll just come to it in details now. He was all at the time on the earlier night with Mohit Hojai. He was staying there. That is the evidence.
In the flat of Mohit Hojai. Yes.
From there, he rang up PW21, that is Chandra Sharma.
Yes.
Chandra Sharma for the vehicle. Now, why the vehicle? That your lordship has to inform us. That is where. That it has to go Mohit knows, Mohit knows, then Lama knows about it. And
Which
it
was the
it
vehicle?
has to disappear, my lord.
Which was the vehicle of Chandra Sharma? Tata Sumo?
Ah.
Tata Sumo?
Tata Sumo, Tata.
So how is the Tata Sumo related to the Scorpio? One is Tata, one is Mahindra.
No,
Now are they related to each other?
no,
Competitor.
only.
Only because they are traveling on the same road. Right?
There, that is why I say, Marat, these are all addition pieces of facts, Marat, which are proof fact that has to be pieced together for deciding where.
Gentlemen, we are still trying to move from the blocks, right? In a race, the runner starts from the block. So we are trying to move from the block. The first block is how are the two vehicles and the occupants of the two vehicles connected to each other? Give us that evidence first.
Marat, the only connection from record, I cannot say anything, that's from record. That they were moving together to same destination.
Who says so?
Same thing.
Who says so? You should have followed them. One might have gone to Doki Lake, the other might have gone to Cherrapunji or Letlam, we don't, for what we know.
That is not, I'll humbly submit, but that's not.
They were going to the same destination. Who says so?
I'll submit it. I'll submit it that they were.
You are arguing after the matter has been decided. Evidence is over. There is no further investigation to be done.
What they have decided in the earlier night, that they had to go take this amount and deliver it to someone. That is what. So accordingly.
Where is that secret information? Please?
Accordingly on the past.
Where is that secret information?
That is all there.
Where is that GD entry 1176? That is a number. Where is that entry? Whether you, we will say you have hidden it because there was no reference to two vehicles in that entry. We will say that. What do you say? Why you conceal that entry from the court?
All this, what has the comment that was placed? What about that has come?
All right. Now, Mr. Counsel, just Mr. PP. We are dealing with an FIR which was drafted by a seasoned police officer, right? Exhibit P37. What is the FIR? 37. Read, please.
That 61, page number 61. To 63, volume 1.
61. Then, Rupam. Yes. Exhibit.
Exhibit volume 1.
And don't preach a sermons. FIR is not an encyclopedia.
I'm reading the.
Yes. Read.
Page 63.
Yes.
With reference to the above, that is the Basista PS GD entry number so dated 1/4/2009. With reference to the above, I beg to report that on the basis of specific source information, today on 1/4/09 at around 4 p.m., vehicle number A01 AH1422 Scorpio and A01 L0609 Tata Sumo were intercepted at 14-mile GS Road, and on search of the vehicle, the following persons suspected to be the cadres and linkmen of DSDJ organizations were found occupying the vehicle, and from their possession a sum of ₹1 crore meant for purchasing sophisticated arms ammunition to wage war against the state, as well as to carry out their nefarious and illegal activities, along with 2 pistols and other documents, including blank letterhead of DSDJ, were recovered, which were seized accordingly.
Okay. From this FIR, tell us Which was the vehicle in which Fojendra Ojai was sitting? Which was the vehicle in, just hold on, please. Which was the vehicle in which Babul Kemprai was sitting? And from which vehicle the cash was recovered?
Matter, I think it will come up in the seizure.
We are reading, we are asking you to refer to a typed report. Your IO did not have access to a laptop at the spot. He drafted this report after reaching the police station. Where was the cash?
Just mention them all.
What was the sequence of the vehicles coming? Where do we get it from? Any document. Men may lie, documents do not. Circumstances do not.
Then
And
become 64 and 55.
yes, read 64. Read the sequence in which the vehicles came.
Search and seizure. Proposal to that I, Sri Moizuddin Ahmed, opposite the PS, do hereby search the intercepted vehicle belonging registration number A01 A1422 Scorpio and A01L0609 Tata Sumo at the above noted place, and on search of the vehicle numbers A01 AM1422 occupant Fojendra Ojai with driver Dunu Sonar are found, and on search of their belonging found 2 pistols in a briefcase along with other documents, and on search of the vehicle number A01L0609 found occupant Babul Kamprai and driver Dipankar Deka and a big airbag containing huge amount of money reportedly kept by
Yes, where does this come from? Where does this line come from? Who told the seizure officer that this money had been kept by Fojendra Ojai?
It has come here, Mother, that it was reportedly told by Fojendra on interrogation.
Well, let us be benefited by the interrogation note. There was no occasion for interrogation having been done before this memo was prepared. Was there any interrogation before that? Does Moizuddin Ahmed say so? So there is no sequence. All right, assuming that the sequence was not there.
Let us accept as it is, Mother. Let us accept.
Yes, accept as it is. So there is no sequence of the vehicles coming, right? Okay, now you tell us on what evidence do you link Fojendra Ojai with this cash? Tell us the best piece of evidence you want to rely on. Babul Kemprai in 313 doesn't say that the money is of Fojendra Ojai. So that 106, you can't put it on the head of Fojendra Ojai. Babul Kemprai for you is a small fry. The big fish is Fojendra Ojai.
Yeah, Fojendra Ojai, he denied.
So no 106 against him? So please provide us the link between Babul Kemprai and Fojendra Ojai.
So what would the accused here say that? He said that
who says?
On the that is question number 11. It is a fact that huge amount of Indian currency was found inside Tata Sumo AS01 E0601.
Oh, gentlemen.
On the request of Fojendra Ojai, I boarded the vehicle.
Who says so?
Babul Kemprai.
In 313. Read.
Yep.
Read. Page.
Question number 11. Page 878.
878.
878.
Next volume, please.
Babul Kemprai.
Yes, which answer?
PW10 also testified
Yes.
that on SARS, they found 2 pistols in a briefcase and other papers in a Scorpio and 1 airbag containing huge amount of
Okay.
currency in Tata Sumo, and both the vehicles was seized. PW26.
He says, I did not carry any bags with money.
Mala,
Yes.
answer is I was not aware of the activity so and so. It's not correct. It is a fact that huge amount of Indian currency was found inside Tata Sumo so and so, but I did not carry any bag with money as the vehicle was going without any passenger. Therefore,
Yes.
on the request made by Protender Vajay, contractor, I boarded the vehicle at Ganeshkari.
Okay. Yes. Now tell us the law. That statement made by an accused in 313 can be read against another. Which is that law?
I'll have to learn up law. Madam, may I please? Madam, may I please? 2006-10 SCC.
Yes.
681.
Yes, please.
Tribuk Maruti Kiran.
What is? Dena bhai, Dena.
Paragraph Marat 11, 31 and 32.
Let's see the judgment. Just one. Yes.
Paragraph 11.
11.
If an offense takes place inside the privacy of a house and in such circumstances where the assailant have all the opportunity to plan and commit the offense at the time and circumstances of the assault, it will be extremely difficult for the prosecution to read evidence.
What are you doing? This case of two persons being in the same room, one being found murdered.
The law does not enjoy a duty on the prosecution. Let me complete. The law does not enjoy a duty on the prosecution to delete evidence of such character, which is almost impossible to be there or at any rate extremely difficult to be there.
Gentlemen, it would have been different if they were found in the same vehicle. They were in different vehicles. So how do you link the person in one vehicle with the recovery weight from another vehicle? We have given you a dozen examples. What is there in the pocket of Mr. R.K. Chaudhary? You can't be held responsible for that. Understand? So how do you link Fosendra Ojai with that currency?
The only, of course, whatever, we cannot say anything more than what is there, man. The only link is that the vehicle was, two vehicles was moving to the same direction to where they were told to do. There is a
Direction, Guwahati to Shillong.
Yeah.
1,000 vehicles in an hour.
Particularly these two. Particularly these two.
Tell us, they were just moving back to back,
where
bumper to bumper. Tell us.
Where they were carrying the cash as well as the documents, etc. and all. Nothing was. There were thousands of vehicles, they were all innocent. But that is how.
That's okay. So now next question, just Mr. Das. Mr. Das, just hold on. This judgment is of no use to you. Fosendra Ojai is a cadre of DSDJ. Witness. Evidence.
We can, from the evidence, and from his own action, we can say that he was sympathizer.
He was a
Sympathizer.
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 All right.
For the-
You-
for
Do you
the-
see from the FIR?
No,
Do you
for-
see from the FIR
No,
the predetermination of the prosecution to somehow or the
my lord, the only thing is that, but what are the evidence that has suppressed?
Mr. PP, just hold on. Evidence was collected subsequently. Your IO was predetermined even before the seizure that somehow or the other this has to be linked to DSDJ. You don't produce that secret information, GT entry, and you write in the FIR, suspected to be DS cutters and linkmen of DSDJ. Where from? For a moment, let us ignore this action of your seizure officer. Now all evidence is before the court. Tell us who is the witness who says Fozender Ojai is a cadre of DSDJ. Tell us, please.
No, I don't.
You don't.
By his name.
Of course, his name, he is not holding any post. It has to be by his name. So we now take note that Mr. Das candidly conceded during the course of arguments that, and even if we don't take note, he will remind us.
Recording, my lord.
Now move forward. Now, just hold on. This was part 1, part 3. Terrorist acts of DSDJ. Evidence, please.
I have already.
Yes, tell us. This is a very serious matter. Nothing to be brushed aside lightly. We need your assistance to find out what are the terrorist activities. The defense, of course, will project their case in their own manner.
My lord, I'll just give those evidence for my lord PW. PW 46, PW 20.
Just wait, one by one. PW 46. We will just briefly look at the statements. 46, page. No, it's second, volume 2. Volume 2. Here is it. Let us see. Page
378.
378. Read, please. Who is he?
He is a
Nairing Dolagupta. Yes. Militant organization.
Militant.
So, can a militant organization be equated to a terrorist organization?
Gang.
And this is 95. 95. We are in 2009. In 2003, Joel Garlosa went and formed another organization. Assuming so. So what were the activities of DSDJ?
Separated and 12 went and from another militant organization by the name of DSDJ.
Oh, yes. All right. Now, organization is formed. What are its activities? Even from inferences, let us know. What a wonderful job that Satyaprakash Pani, he was the witness. Amitav Sinha, a detailed list given. What was the result of investigation? Did the investigating officer conclude in any of those cases that this was the hand of DSDJ? Yes. Next witness. So he simply says his evidence may be sufficient to constitute the fact that there was an organization called DSDJ which came into existence in 2003. What beyond that? What were the activities of this?
This is a militant organization.
What do you mean by militant organization? Is it defined in UPAP?
Carrying on armed struggle.
Tell us, sir. Some witness should say
Demanding their
formation of an organization. It is not a declared terrorist organization. It's a fact. So existence of a militant organization or to be a part thereof, is it a charge or is it a conviction? No, obviously. So assuming for a moment, because it's a case of such a sensitive nature, that yes, this witness says that, and it is acceptable that there was an organization called DSDJ, which was formed in 2003. Okay, then what about its activities?
Here, we were referring to PW2 also, my lord, that is strong, 20, my lord, wrong Singh Lanka.
Oh, yes, PW2.
20,
Let's see, sir.
20,
PW2.
20. That is at page 68.
PW2.
20, sorry.
20.
68. He is also a DSD cadre.
Yes, DSD cadre. Yes.
Now, he is from the year 1996, Joel Carlosa was the chairman. Dilip Nonisha was the vice chairman and Pranav Nonisha was the commander in chief.
96.
Entered into ceasefire with the government.
Yes.
After ceasefire, Joel Carlosa.
So yes, all your witnesses says 2003, Joel Garlosa disappeared. He formed another organization. What are the activities? We are trying to find out that. Even those accords which were signed in 2010, 9, 11, 12, you have not even proved those.
Another question,
that
unless this is a terrorist gang.
Yes.
All along, they sat with the government for a quite number of time. And what has happened, Malo? My friend has brought on record, Malo, you all have seen it.
Yeah.
My friend has brought that miscellaneous case, bail petition before your lawsuit. Where they have admitted. Malo, what happened, Malo?
Assuming, for a moment we are saying assuming that you proved that he was the chairperson of DSDJ. Then what? Then what? What are the activities of DSDJ?
DSDJ. Malo, the extortion.
Tell us, please, evidence. No stories here.
Yeah,
there is a magazine called Manor Kanya. You're not reading that.
That is the evidence of PW 126 Dipolar Hojai.
Yes, read.
126. Malad 126, Malad 625, Malad, that is volume number 3, Malad.
Yes.
Volume number 3.
625.
625.
Read, please.
The admitted person. Yes. Gone hostile.
Yes. So.
Malad, your Lord, may turn to page 629, Malad.
Yes,
2%, 629.
yes. Read.
I know Daniel, who was a member of DSGJ. At present,
Yes.
he is an elected member of the council as an independent candidate. Now he joined BJP, so and so, so and so. Then it is not affected. Since before my time of taking CEM, many efficient government officials were reluctant to be posted in NCL because of the problem of activism and because of this developmental work suffered to a certain extent. There were two groups of extremists, one DSDA, another is DSDA.
Yes.
And there was also presence of other extremist group. It is a matter of common knowledge because of the extremists and extortion developmental work was suffered. There were also killing and kidnapping by the extremists. Details of which could be found in the police report.
Yes.
After my got it.
Common knowledge. Under what section of Evidence Act will this be admissible? Tell us, please. 33 or section 6?
The only difficulty with us, that this witnesses are very reluctant to.
We understand. You are NIA.
Their own problem.
You are NIA. You are required to procure documents. Cases in which charge sheets have been filed. You fail to do so. What does this prove? He says, Joel Garlosa, DSDJ, Joel Garlosa. Assuming. What after that? Who after that? What does he have to do with Mohit Hojai? What does he have to do with Hossein Hojai, Babul Kempai? Defalcation, government servants indulge day in and day out. They provide good subsistence to lawyers who are appearing in PCI cases.
They have to sustain
They're-
themselves.
Yes.
The extremist group, they have to sustain themselves only with money, otherwise they cannot carry on their sustain.
So this money
They need
which you
money.
say, yes, how do you establish the trail? How did it reach the DSTJ? Tell us that. It's a case of terror funding as per you. Money defalcation is rampant everywhere. 6 schedule areas, everyone knows what is happening. But can every defalcation be linked to a terrorist activity? It is an economic terrorism, no doubt. But the persons themselves are responsible. Those who are indulging in defalcation. The prosecution agency which fails to get the trials of PCA concluded within for 12 years, 14 years, it is also responsible. Equally responsible. Why the CBI trials are still going on? Why have you not concluded those proceedings?
That is of course
So anyhow, that is a different subject. Now tell us, Joel Garlosa, member or a leader of a terrorist organization. He has not been convicted for that. He has not been convicted for being a member. 20, yes.
20 is there,
All right, 20. What about the others? Niranjan Ojai. Niranjan Ojai. So Niranjan Ojai, who says so? Tell us, member. So, do you deny the fact that so far as terrorist activities are concerned, there is no tangible evidence on record, other than the stories your Amitav Sinha has said?
He said about my submission, he said about the fact that was going on in the field.
So that's the story that these things happen,
But
but he is not a witness
May I
to those
May I
activities.
just expand it a little more? May I just expand it? Just what is happening in Manipur, my lord? That's not all. If anyone deposit, because he may
News
not be-
reports,
He may not be the person who has. witnessed
news
it.
reports are the substantive piece of evidence.
He was there. SP
He was there. He says that these things were happening in my area. What of that? Whether any inferences can be drawn by that? Hard evidence, section 75 Indian Penal Code. To prove the past conduct, 3 convictions. So how is it to be proved? Bring the judgment on record. So you wanted to prove the conduct of DSDJ. Why didn't you file the charge sheets on record? Not one charge sheet. Any of these persons charge sheeted for that purpose.
My lord.
You say policemen were killed. There must be other witnesses, survivors. Where are those cases? We want that these people should not escape.
Okay, my lord.
But then we need
Separate.
positive evidence to keep them behind bars.
Honorable Kanta has brought those FIR. You all will remember that.
FIRs, Mr. PP, what is the charge sheet? Did they culminate into a charge sheet against any member of DSTJ? There is reference to Joel Carlosa in one FIR. Suspected. Suspected extremists. Suspicion household strong cannot take place of proof.
Just like the present has heard.
Where are the charge sheets? Why you as a public prosecutor didn't ask the investigating officer? Get me the charge sheets now. 311. We got the charge sheet in a moment, notice. Placed. Are you sure?
No.
Look at Anurag Sinha's statement.
No.
Any single charge sheet of those incidents. No. Carry on at what? 2. We'll meet at 2.
With Mr. Ken Chaudhary, he has agreed for first. Only the issue is that Lordship, since the division single bench's order of the Guwahati High Court was overruled by an OM. And now the problem is that massive promotions are being done because there was no interim order. I paid for it, I was refused. So, Your Lordship, that urgency is there because once the 2 matters are decided, the principle will be applied in the other. Only 3 matters need to be decided, the appeal and the OM challenge. So can I pray that matter first? I have to taken it.
We already given you the liberty to make a mention to the court master. You don't need to mention the court. Whatever date the councils want, we can very well take it. Okay. Yes. Passed over, yes. There was on passed over matter. Yes.
Bharat, GMC Council.
Is here. Yes.
Yes, he has taken a decision, Lord. Only the signature is standing. It is on his paper. And there is not one appeal section is also there, Lord.
One
Appeal section is also there, Lord. If
appeal
he-
provision now.
Appellate
We know.
He is agreed, then he can.
All right.
Now, Lordship, in between, Lordship may be protected because we do not know that because on last occasion, there is a rival going on.
Till the-
Immediately they attack our construction, my lord.
We'll post it tomorrow. Present the order for us or a producer. Okay.
Yes.
Mr. Nayak appearing for the GMC. GMD.
GMC,
GMC, submits that the competent authority has already passed a speaking order in terms of the direction given by this court, by the learned single bench. He shall place the same on record. Place tomorrow.
That what speaking order is. No, I don't know, Lord, what kind of order.
Pass an order as a consequence of such.
Tomorrow.
Place tomorrow. Yes. So we were on the aspect that assuming you have managed to prove the link of Joel Carlosa as being the chairperson or the leader of DSTJ. For a moment, we assume what is the evidence to satisfy the court that this organization, after being formed in the year 2003, indulged in terrorist activity? Second part, that the funds which are subject matter of this appeal, this criminal case, which were defalcated from the NCL's development budget, they were provided to any person connected with DSDJ. This is the core question for you. Drawing inferences of conspiracy is one thing, but what is the substantive evidence as per you?
I can also get gone through all the people, nearly all the people. They generally they have said about the not that from 2003 after formation, it has come after 2009. Teaching has that whatever vacancy. Only your will come here to the conduct.
Conduct of which witness? Which accused? Joel Carlos. Tell us what is the conduct. He was found living at Bangalore. One conduct. He was found working out in a gym. Second conduct. Third.
In the vehicle, DSP that I had.
No, big question mark on that.
No, he himself in Bangalore.
He
on assume name in a fake.
Who says so, gentlemen? Yes.
Evidence has surfaced.
Okay. All right. He assumes a fake identity. All right. For a moment, assume that is so. Then.
And then he carried out all the operational activities from them.
Now, let us have the evidence to that. What are the operational activities he undertook from Bangalore?
Of course, that one part that the trial court also has ignored that recovery of email.
Not ignored, discarded.
Yeah.
Ignored and discarded are two different things.
That is, he was contacting with DSP and NDFD.
What is NDFD? We don't know.
That is for another terrorist organization. Not listed in the schedule of the UAP Act.
Okay.
That is real what 12 or something.
Yes.
Page 31.
When was the organization listed? When? What is the date of its being enlisted? UAP Act देना और वो वाला अभी वाला ये भी दे दीजिए. Give it this one also.
In first schedule.
First schedule.
I do not know what complete at page 30 of the procedural and 31 serial number 12. National Democratic Front of Boroland.
So this okay.
That is, it is declared. It's declared in the terrorist offense.
Yes. So there was a mail sent.
That is operating, that is operating in more than a
Mm.
year. Now, these, they're not, these terrorist gang organization, they're not working. They need basically they need
Shelter.
because my people are there, they have to hide. Forces that is or security forces. So they have to either tie up with this NDFP or other military. And for all this purpose, you are money is required.
Yes.
I provide you shelter, you have to, I provide you arms and everything. These are going, of course. This thing is not. That is only question of inference. So is real Bharosa.
What was he eating before 2009? How did he survive on thin air?
Before 2009.
How was he surviving? Any investigation carried out in its funds of DSDJ?
Because just NC Hills is a place, now, lot of affair has been. Nothing has happened. Investigation was done, something came out. As we have seen in our case, that all the witnesses regarding hosting of people on has done. That has happened in Hati.
Yes.
It was in special and I quote in.
We understand. That is why a specialized agency has been given this task. That is why the task is more onerous. And if they perform in this manner, what should the court think? Are you hands in glove with these people? Is your agency not responsible for such shabby investigation? Was it and motivated?
Yeah. Actually, just bear with me. After there is a amendment section is there. 43.
43. Yes.
Now, I'm not taking to the whole of it, just section 2A. You also be favored, in other cases, there are 30 days, 60 days, and 90 days. That you have to file the survey if the person starts.
Yes. 167(2).
Yeah, the amendment is about up to 100.
Yes.
100.
Oh, that is just like NDPS.
What I'm getting at, here, the conspiracy, it took place in NCT at Guwahati, in Bangalore, Kolkata, and of course they went to somewhere borderline of because Niranjan Hojai was arrested in the border areas of Nepal. Now, all these investigations, it cannot be completed in 180 days. These persons were arrested. And if you don't, as your Lord is aware about, if you don't find the 30, that otherwise they go. Because
what will happen? They'll come out on bail. How does it make a difference?
That is where. This is where, we prosecution things.
You file a partial charge sheet. What prevents you from doing that? File subsequent charge sheet 173(8). N number of Supreme Court judgments. That you can always supplement the material already presented. And that doesn't give right to the accused to seek default bail. Merely because part of investigation is pending.
Appreciate it, what has come out from Lord. They have not done anything. They thought that we will file it in 180. That is not. That is actually that is what has been done here. So, yeah.
So sloppy investigation, justification is that we wanted to do it quickly. That is why, right? So we do a shabby job of it. Excellent. Should be certified that in such an important case, dealing with such people who are branded to be terrorists, such a fantastic investigation is done, that you even don't prove the arrest memo of the accused. And you want to rely upon the disclosure statements.
Yeah.
So now, all right, the third question is still pending answer. What terrorist activity?
I think I have forgot that the statement of P2 to 20, 23, 24, 126, 129, 70. That's already ideological.
So tell us briefly from their statement, which is the terrorist activity which these witnesses have stated about, other than a general observation that it was involved in such activities. Which activities, gentlemen? Which train was stopped? Which train was fired upon? Who was kidnapped? Where ransom was demanded?
P2 20, and that is Rosling Bankara.
Yes, read.
Especially.
Yes. Yes.
Garlosa group kill Ojit Goro after taking out his eye.
Yeah, let's read his complete statement. Yes. Does he say so? Really? So you are trying to again admitted portion. Let's see. I also deny the following statement. At the time of last council election, they killed Purnendu Langtasa and so and so. Deny, deny, deny. Yes. Next. 23. All right.
He only
23. Kulendra Dalako.
he only said about going to Kuala Lumpur.
Yes.
Uh,
So what is the objective of DSDJ? Demanding more autonomy to the council.
The only important about this witness, Maro, as I have already said, Maro.
Kuala Lumpur.
Unless Niran Mujagi is so important, they would not go there and discuss the affairs of the NCD with them. He was a person who they think would control the affairs of the NCD.
Mr. Prosecutor, did you give a slightest suggestion to this witness that Niranjan Khojai has something to do with DSDJ? It's good. He's a kingmaker. He was asking if you have any aspirations. What is wrong in it? In India, every second man is a kingmaker. He thinks that the government is elected because of him only. मैंने वोट दिया इसलिए तो जीती है सरकार. Fact है. That is the right of franchise. That is democracy. So Kulendra Delagapu, what do we gain out of that, sir? What do we gain out of that? Niranjan Ojai posed himself to be a big shot. Big shot for what? NCL this area. Yes, so what of that? Controlling affairs of what?
Unless otherwise EM as well as CM goes there and dictates. Excuse me.
You are sitting here and talking about the 2024 elections with Mr. Arkadev Chaudhary. So means the person goes to a foreign country and talks about political affairs. That means he becomes very influential. Is that so?
He takes the permission that I am going to.
Don't talk rubbish. That is. Yes. Amitabh Sinha, do you want to read? Read, please. Read. His entire that part wherein he says that these were the activities. That is an improvement admitted by the witness. The trial court has misread that part. Not once, twice he was confronted. So Amitabh Sinha,
46
Nairangdal, 46. Just hold on. PW 23, PW 24, PW 20, PW 46. Okay. 378.
Just 2-3 lines, madam.
No, you take your time. Yes.
Commander, our military camp, we are always on mobile. Whether you used to move, so the arms and ammunition were received at the message. Then in October 2013, and from another military operation by the name DSDJ in the year 2006, when I came to liaison office, the from to meet with nourishment around my return to my camp and from Hong Kong. On my way, I was attacked by the so and so, another person belonging to DSJ group. On this attack, I received 6 bullets from AK-47. That is the person who made a statement before. He's the person.
He made a statement. What does he say about Niranjan Ojai?
Both they come together. I'll just both.
PW 46, Niranjan Ojai. Does he utter a word? He was a witness who was supporting you. You could have asked him to oblige you that Joel Garlosa group DSDJ is still engaged in terrorist activities. He says 2003 ceasefire. After that, what?
There is always a difficult that you don't get, you always apprehend a negative answer.
So you apprehended that he will not oblige you. So rather not put a question. Does that help you prove the things?
Get the answer that you are thinking about.
So
That becomes very difficult, my lord.
Where does this testimony take you?
Whole evidence.
This testimony takes you only to the fact which you have already stated. DSDJ Joel Carlosa, that's all. What thereafter?
My lord, these are the evidence I have read, my lord.
Yes.
This terrorist, organization terrorist act. my lord.
Terrorist act, sorry, you didn't read a single word.
Terrorist.
Not even terrorist organization. An organization named DSDJ. That is all. Whether it is a terrorist organization indulged in any kind of terrorist act, none of your witnesses says.
Is the evidence of this Narang Tulako, my lord.
Nerang Dalako. Let's see again.
Narang Tulako.
Yes, let's see again.
Yes,
46.
they say that these are the members of the DSDJ group who have attacked me.
Yes, where is that FIR? Where is that FIR? A bald ipse dixit of the witness. I was attacked.
May I take a lordship now? Section 10.
Of?
Evidence.
Yes, please. That is good. Now we are going. Yes.
Whether there is visible ground to believe that two or more persons have constructed
So first, reasonable grounds to believe that two or more persons have conspired together to commit an offense. Which are those two persons first? Let's know. Which are those two persons? There has to be existence of two persons.
more persons.
Two or more, minimum two. Which are those two?
Yeah.
One is Joel Carlos as per you. No.
We are having different side. We are having here Fazendra and Mobile Camper. With Mohit.
Okay.
Then we are having Mohit Vijay and Niranjan Jay at Kuala.
And at Kuala Lumpur. All right. Yes.
Then we are having Niranjan Joel Kalosa
At Bangalore. And Arshindra Varisa at Bangalore. Yes.
Bangalore as well as Mother, this general and because they have been carrying the command. Again, I'm coming there. But they ask you, your respect, I say.
Your task has been made tough by, we'll tell you. You know, I will just tell you, we have all sympathies with you. Your task has been made tough by incompetent police officials. You see, agreed that at that time NIA was not in picture. But these are people from Assam police who had some degree of experience. What kind of nonsensical exercise they did at the time of the recovery. We showed you. And then there is that one observation you remember. You will have to explain. In absence of your secret information, how could you mention in the FIR that this was meant for a terrorist act? What was the material with you? Mention that. That creates a grave suspicion on your motives. That even before the recovery, you are bent upon to prove that it is just meant for Yes. So two were carrying cash. Understood. What thereafter? What was the cash meant for? Where from the inference is to be drawn?
Yeah, that is. Yeah.
Inference of section 10. What was their common design?
To deliver this money to a particular part.
At Shillong, are you sure?
That is the evidence of.
Your witnesses say Jorabat. Jorabat is not in Shillong.
They were intercepted. Intercepted. They were caught at them. But they were.
To give it to armed smugglers in Jorabat. No. All right.
Uh, 26, he said,
Read first PW2.
I was posted on 149. I was posted in front of contact the Dr. King and came to our police station and reported of villages are going to deliver money to the express at Sarawak area.
Okay. Hope that our recollection was correct. Come to PW10.
Sure. Evidence part of that might be one of the that is
PW26. Already read 26 also, sir.
He was carrying the money to be delivered to one Mr. Diana, who was an armed dealer.
PW26. Let us first reach there, sir. Just stop. Sudhakar Singh. Let's see. Does he say where the money was to be delivered?
What introduction it was stated by Mr. Presenter was that on the direction of one Mr. Niranjan Hardai, he was carrying the money to be delivered to one Mr. Diana, who was an armed dealer.
So now this is again a fabrication of the highest order. If at all he had made this kind of disclosure, why was it not incorporated in our FIR? Why was it not taken down into writing? The accused were in your clutches. Why didn't you record this information? Why didn't you try to track the lead?
If it only created carry the information. Same thing. That's so and so. These are
What your additional SP says, where is it recorded that Fozendra Ojai made a disclosure? No. Okay. So now please conclude regarding Fozendra Ojai. How do you want this court to infer that this money was to be provided to some terrorist organization. From where this, assuming for a moment your argument that Fosendra Ojai was aware about this cash. Okay, from where that inference is to be drawn.
That is why I was trying to, my effort was that, that since they had been carrying this huge amount, for them to say why they and why this amount was carried by them, to whom, whatever it is, they said that we are all contracted. They could have said that.
He wanted to spend it on a 7-star resort.
Whatever it is, some kind of explanation whatsoever.
Why was he required to give it?
Because that is within their knowledge.
Just hold on, sir. Cash in hand by itself is not an offense, is it? It is.
No.
Is it not? Then why a person is required to explain? If there is anything, any incriminating circumstance, 106 deals with incriminating facts. Facts, especially in knowledge, but they should be incriminating. Then they require an explanation.
Being a huge amount.
All right. Huge so what? You are not treated to be illegal. You are not given information to income tax. Then only provision of law at that point of time, which could have made the recovered cash liable to some, just listen to us, sir. Just listen to us. At that point of time, only ostensible legal provision by which that recovered amount could have been brought under any deviation from law was Income Tax Act. Unaccounted cash. So he is not a public servant that is required to explain. Well, he doesn't explain. Give to the income tax. They will deduct whatever is to be kept, give it back remaining to him. All right. Now tell us why he was required to explain.
Another incriminating factors they have been paying is their DSG letter.
Oh, yes.
Along with the care.
That, yes, okay. DSD letter, yes.
Yes.
Okay, very well.
It is for
That, okay.
These are the case
That is it. Okay, that part is over. So two facts on the basis whereof you want to link Fosendra Ojai and the recovered cash with DSDJ. Number one, that the cash was huge and there was DSD letterheads. No evidence of any witness to that effect. That's right. Okay, now you can move on. Just when we are at this point, how are the articles received in the police station? This amount, those documents, how are they received in the police station? Where were they kept? As of now, we are now 14 years down the line. In the DSDJ letterheads, where did they go? And those two weapons, where did they go? There? Oh, exhibited is all right. You can print 19 a dozen. Go to the market, get a printout taken. How are they kept in the police station? The letterheads so seized, do they bear any indication that they were being seized in connection with this recovery? This FIR exhibit P37.
Seized together along with
Read Maizuddin Ahmad. Come to page 2. Come to page 2, please. 38. Yes.
Today I have seen the seized article, 32, is a state armed by the.
Just 10 lines from the top. 10 lines from the top.
Yeah. What line from the
One American briefcase.
the case which was seized where amount it is one.
3 sheets of letterheads blank. Letterheads of which organization?
Briefcase containing documents, including 3 sheets of letters. Yes, 3 sheets of letters. Blank.
Which
And a letter.
Which organization, sir? No organization. Now come to next part. Come to page 41. Cross for Devashish Bhattacharya. Last, second para, last 3 lines. Read out aloud, please.
It is not perfect that
The seized articles do not. The seized articles do not.
no I connected
No, above that. 3 lines above that.
These articles do not bear the sequence of step. Yes. That is, there are no signatures.
Then come to the top of this para. There is nowhere mentioned in Exhibit 37 that the seized articles were properly sealed after seizure in Exhibit 38. So what is the sanctity of these documents, gentlemen? Then come to page 43. On the date of seizure and itself, the arms and ammunitions seized by Exhibit 38 were handed over to in charge Malkhana of Basista police station for recording in the Malkhana register. Okay. Who is the in charge Malkhana? Where is the entry of Malkhana? It's not there. Any further arguments on this point then? It's 37. Part 2, volume 1 dena. More important. Yeah, I have it. I have it. And one more important thing, Mr. PP, to see how things are planted. There was one letter of Mohit Ojai also with this seizure. Read your exhibit P37. Is it mentioned? Is it mentioned? You have tried to draw much water on that letter. Yes. Where is the reference to this letter in your FIR? Have you read the type report, sir? It's not so long. Just 7 lines. Where is that letter had gone? Exhibit P37. Don't read the Caesar list. We have seen that. It's there in the Caesar list. And not that your FIR doesn't make a reference to documents recovered. It does. 3 letterheads. What about the incriminating letter? Next question. Read Moizuddin Ahmed and Sudhakar Singh. Okay. Where was the seizure taken place? Where did you conduct the exercise of seizure? We'll come to the 2 drivers later.
Activity.
So it is at page 42. So it took more than 1 hour for carrying out the said operation, including the preparation of seizure list at the place of occurrence. Okay. Now come to Sudhakar Singh. PW 46 or 26? 26. Read, please. Page 137. 137. Second para. Read, please. Read, kindly read. Where was the seizure made, sir? You didn't get it. Page 137. Sudhakar Singh, third page.
Verified and they were not to the object of hearing, thereafter the seizure is
So now you please recollect your two punch witnesses. Dipankar Deka and Bunusuna. Budapani. Not declared hostile, not cross-examined. So where did the seizure take place? Please tell us. The actual interception and the seizure list, where were they prepared? And that is why the omission in the FIR assumes more significance. How do you explain? Facts, especially knowledge. 106. This was known to only Maizuddin Ahmad and Sudhakar Singh. Where was the seizure made? Where was it made? Yes. To cover one lie, you have to create 100. Right. So now that seizure part, thereafter what? Yes. Now, please tell us what is your argument regarding link of Hossein Rojai with DSDJ or any of its activities? What is the evidence to infer that?
therefore it is here. In this whole
Context, where has it appeared, sir? That's what we want to know.
Slowly-
Appeared in what document, what statement?
Maybe
Inference from what set of facts? Which set of facts? We understand. Inferences have to be drawn. Mr. Kamar very well said. Conspiracy can be inferred from a set of facts. What are the facts from which this fact is? This fact is to be inferred. Inference of one fact from another bouquet of facts. What are those bouquet of facts? Which are the flowers in that bouquet?
It's not denied that it's not denied.
Now, please don't raise that argument. Not denied, no. First, you state your case. Stand on your own legs.
On 1409, the vehicle were proceeded.
Vehicle was going on road, so what? Okay. Babul Kempray was carrying 1 crore rupees. Okay. He admitted in 313. Then what thereafter? You are again moving around in the same circle. He told you that recovery of cash by itself was not incriminating. So why is Fojendra Ojai required to answer that? More particularly when it was not in his vehicle.
That is where it's appeared that interest may be drawn.
From what fact?
These facts.
Okay. All right. That's your argument. Inference of what? That Fojendra Ojai knew that 1 crore rupees is being applied in a vehicle which is following him. He did not inform to the income tax department. So that is an offense.
There is another factor we have to go to that. He was talking to Nirajan Ujai. The mobile has been seized.
After seizure.
That has come on.
After seizure, after the mobile was in your possession, how could he have talked? He was in your custody. The mobile was in your possession.
No. At the time.
Mr. PP, now we prohibit you from doing that. Your seizure list says 4 p.m. The call details is at what time? Don't venture into that territory, please. Don't go against your documents. The trial court has done whatever it was to be done. But now we don't allow you to take that kind of nonsense here. What time was the seizure made? As per your list. Hmm. 4 p.m. Was it a symbolic seizure? Paper possession or what? That is your claim. No, you allowed. All right, let him talk to his friends. I was so seizure officer was so benevolent. You should have filed one more case against him of snatching property which had been seized. There is something called arrest and personal search memo, right? Where is that memo of Fojendra Ojai? What is the exhibit? Presumably, you must have found the mobile only on that when that exercise was carried out, right? What does Maizuddin Ahmed say about that? I took the search of Fojendra Ojai and from his person, I found this Sony Ericsson mobile phone. Read. What is the exhibit of the arrest memo?
Activity 7. Only mobile.
Arrest memo. Does your seizure list say that this mobile was seized from Fozendra Ojai? What is the exhibit of arrest memo? Not exhibited. Oh. Mr. Prosecutor, what is the arrest memo of Fozendra Ojai? Exhibit?
Exhibit panel.
Read one document from file, entire file. Read one document from the entire file, which is sufficient to make an inference that this phone was recovered from Fozendra Ojai.
At page 65.
Yes, read please. 65. Read. It is at page 66.
Page 66. On Sony Ericsson mobile.
Phone of Fozendra Ojai. How does your seizure officer draw this inference?
Giving serial number 10.
How does your seizure officer draw this inference that this is of Fozendra Ojai? He writes in the exhibit 36 that this cash was kept by Fozendra Ojai. What basis? So, conversation with Niranjan Ojai. It was seized at 4 p.m. Now you explain 106. How there was a conversation after you seized the mobile phone. It was in your possession. Why don't we infer that you talked to Niranjan Ojai? You means Maisuddin Ahmad. Why shouldn't we presume that? He had links with the SDJ. Why not? Right? Maisuddin Ahmad. Okay. Next. So, conversation with Niranjan Ojai. That is the next argument. What thereafter? Whether that call detail was proved? Yes.
Last one.
Last one. Okay.
Regarding Anal Thana.
Ballal Chana. Yes. That is important.
It is 331, 313. Question number 5. It says, since no material was found against me, that case, so I have been rightly served. That is, the picture of your document of one. Exhibit 41.
Yes.
Where the discrepancy was his name.
When was he arrested? Let us know first.
Upcoming. The discrepancy about his father's name and also his name. We do not know father that the common record.
This was a part of your specialist team investigation, right? Mr. Kamarial.
Mrs. Kamil.
When was he arrested?
That was for 2009.
Are you sure? Okay. What is the time of arrest? Actually, you see, this is 31st July and the disclosure made more of 30th April. Yes.
And in the petition, my lord, his name is.
Oh, Mr. Prosecutor, forget about the name. When was he arrested by your Kamrial? When was he arrested?
Was arrested on 27th.
Arrest memo?
It is a short set call of that he is arrested on 25th.
So disclosure statement without proving arrest, is it admissible?
Or a disclosure.
Disclosure is at? I'm already having that. And what is the exhibit of the seizure, please? 250. 250. Page. What is the page?
One 5. Exhibit paper book of 5.
5 then up. Volume 5. Volume 5.
One
1154. Yes. Vanlal Channa, what we want to do of that? What is to be read against him? So thus, your arguments for prosecution have already been done. Now we are giving you an indulgence. Don't try to stretch it too far.
My only to clarify others the thing. Although
Are you really trying to argue that this seizure was made at the instance of Vanlal Channa? Is that your argument? Then
can I point out that this fact? Can I point out this fact?
yes.
Yes. This Anlalchana Anthea, he has defined it. And which he has located in his given. That's all.
What do we do of this Vanlal Channa? What has he done? What is his role in this case?
That he has disclosed and the recovery made, Maharaj, under his knowledge.
Oh, awesome.
That,
Fantastic. Great argument.
Maharaj, that is what actually it is.
What is the best evidence to examine this seizure? The validity of the seizure or the connectivity of Parlalchana with the seizure? Which is the best material for that, as per you?
Maharaj, we have these two witnesses, Maharaj, which your Lord has already seen.
Oh, Mr. Prosecutor, we are sorry to say, we are hearing the argument of a seasoned prosecutor. What would be the best document to prove the seizure? Witnesses come later. What is the document required to prove a seizure, sir? All right, so thank you. At least you got what we wanted to know. Read the recovery memo and tell us this. This is from Parlalchana.
That is
1154. Mr. R.K. Chaudhary. Give him the document.
Page number 1150. Uh, 1156. It's an article.
This must mention, I suppose, we suppose that this was seized at the instance or in furtherance of the disclosure of Parlalchana. Read column 5. Read column 2.
Person from whom he- that is
Column 2. Acts and sections. In which case was this seizure made? First, let us know in which case was this seizure made. Resolved BS case. Actually, at least the vehicle has moved so much. Yes, please.
I think I have seen it.
So what is your expert comment on that? Please let us know.
Nothing to say about it.
Parlalchana. How to hang this on his neck? How is it to be fixed on the neck of Parlalchana? 106. Which section of Evidence Act? Please let us know. You have seen, what is your comment, please?
Nothing to comment about it. We have seen the fact of the fact.
So, no, please make a candid statement. What kind of recovery was effected from Parlalchana? What is the link of Parlalchana, Joel Garlosa, Hosendra Ojai, Mohit Ojai? Other than the George Lamthang, we'll see George Lamthang later. Could you have anticipated? Now let us put your question. Could your investigating officer have anticipated that George Lamthang will turn an approver so that I shall not be required to make any kind of investigation. You exclude George Lamthang from your scheme of things. How many facets of your case fail? Entire substratum of your case goes. No conversion, no US dollars, no Wallal Channa, no Malsakimi, no weapons. Is it right? So your IO was so sure, but yes, we'll manage to get him approval. No need to make any investigation. Let's leave it to that. That's right. You've done your bit. Okay, you can take your seat. Yes.
My senior colleague has come from Delhi. Let him address first.
This is a rejoinder, Mr. Counsel.
Yes, sir.
You realize that. Yes.
Copy. Only the transit, not the FI. The matter has been, my lords, argued before your lordships, my lords. Your lordships have seen the evidence, my lords, the material. I appear for, my lords, accused number 12, 13, and 14 as your lordships have already recorded, my lords. Jayanta Kumar Ghosh, Devashish Bhattacharya, Sandeep Ghosh. Now, my lords, the lordships have also seen, my lords, that para 379, my lords, after the circumstances have been culled out, my lords, findings start from para 422.
Yes, please.
My lords, I've been convicted for the offense under section 17.
422.
Yes, my lords.
Yes.
422, page 2141, my lords. Just have a look, my lords. I'll just place, my lords, the relevant part.
Yes.
422, your lordships may skip, my lord, it refers to Bidit and Sarda. 423, my lord, then it refers to material particulars. We find, my lord, these are bold findings, my lord.
Yes.
Then 423.1, my lord. Please have 423.1, my lord. The prosecution side has been able to prove beyond all reasonable doubt that the accused Fozendra Hojai, A1, Babul Kempra, A2, Mohit Hojai, A3, Joel Garlosa, A5, Warisa, Vanzan Thana, so and so, my lords, Niranjan Hojai, after forming terrorist gang DHDJ in 2004, entered into an agreement with Redaul Hussain Khan, Karuna Saikya, then Jayanta Kumar Ghosh, Devashish Bhattacharya, Sandeep Ghosh. My lord, with respect, my lords, there is absolutely no material. Lordships have seen that. And the connect, my lords, with DHDJ, insofar as my clients are concerned, my lord, the connect is sought to be drawn, my lords, through Mohit Hojai. So I just pause here for a moment, my lord. The lordships will just note 11 prosecution witnesses have admitted, my lord, that Mohit Hojai is the elected chief executive member of the North Kachar Hills District Council, my lord. One prosecution witness has also said, my lord, that he is a politician, a local politician in the North Kachar Hills Autonomous Council. And Depolal Hojai, my lord, has affirmatively said, apart from the fact that he took over as a CEM after him, he also said that no member of my executive committee at that time, my lord, which also included Mohit Hojai, were related to any militant organization or to any terrorist organization. So, my lord, there is no material, my lords. If Mohit Hojai is out, my lord, And the judgment of the trial court, my lords, is silent on this aspect. There is no finding by the trial judge that Mohit Hojai is a member of DHDJ. And there could not have been, my lords, because there is no material. So, my lords, I was reading 2142, my lords, part of para 423, with the members of, with the lordships will see, my lords, just above, my lords, 423(1), my lords, just mark that line, my lords, third line, have entered into agreement with members of, some members of DHDJ. Who are these members? Not identified, no evidence, just bold findings, my lords. And down below, my lord, to help in raising funds and in order to commit such acts, siphoned of government funds meant for development of NC Hills to terrorist gang DHDJ through Mohit Hojai. Again, no material, my lord. Now, my lords, in 423(1), your lordships have already seen, my lords, I have pointed out. Mohit Hojai is referenced, my lord. And that we were to do, my lords, the lordships will just have 8 lines from the 7 lines from the top. Jayanta Kumar Ghosh, Debasis Bhattacharya, Sandeep Ghosh to do an illegal act, i.e. to raise funds for the terrorist gang by siphoning government funds, convert Indian currency to US dollar. There's no connect insofar as my clients are concerned with all this. To procure arms and ammunition, to wage war, cause death of innocent persons, terrorize people and extort money, disrupts works of God's conversion and construction of East-West corridor. Nothing to do with this case. No evidence is there. It is of course true that the prosecution side has failed to establish kidnapping for ransom held in this case. Notwithstanding failing to establish, other parts have been proved by the prosecution side beyond any shadow of doubt, and the same unerringly points out to the guilt of the accused and accept that no other hypothesis is possible. With respect, is a finding based on no material. Now, then 424. Now, coming to the charge on the 17 and 18 of the Unlawful Activities Act, we find from the above discussions and findings that the accused Redaul Hussain, so Jayanta Kumar Ghosh, Devasis Bhattacharya, and Sandeep Ghosh have either directly or indirectly conspired to raise funds for DHDJ. Again, my lords, no material, no evidence that we anyway, my lords, raised funds for this DHDJ. And we find from the evidence on record that involved in raising and collecting funds, but with respect, my lords, is a finding without any evidence, no material. And they did so by siphoning of and defalcation of government fund allotted for development of NC Hills. And in doing so, they made payment without supply or short supply of articles, making the rate of supplied articles more than double the market rate by preparing false bills, vouchers, delivery challans, money receipts, and provide for terrorist gang DHDJ. Again, my lords, with respect, no material. Lordships will also mark, my lords, those false bills, vouchers, delivery challans which could not be connected to me. Your lordships have already seen the evidence of Rangkhol, my lord, who said that this was all done within his office. Plus, my lord, the CFSL expert, my lord, the handwriting expert who came on the witness box, my lord, AC Kalita, who said that these signatures, these handwritings are not the specimen signatures which were sent to me, namely, my lord, Jayanta Kumar Ghosh, Devasis Bhattacharya, and provides to throw terrorist text. Let's turn over the page, my 2143. The prosecution side has also been able to prove, my lord, beyond all reasonable doubt, that Khojendra Hojai, so and so, after forming terrorist gang DHDJ in 2004, directly or indirectly, involved raising and collecting funds or attempts to collect funds by extortion, kidnapping, siphoning, and defalcation of funds through Mohit Hojai and others in committing such activities, kidnapped R.S. Gandhi and realized rupees 4.5 crore. This, in the earlier part, the learned trial judge said that this could not be proved.
Even in this parais.
Yes, sir. And realized 4.5 crores from him, siphoning government fund with the help of Redaul Hussain Khan, Karuna Saikia, Jayanta Kumar Ghosh, Debasis Bhattacharya, and Sandeep Ghosh by paying money without supply of short supply. Again, repeated, double the market rate, preparing false bills, vouchers, again here, delivery challan, money receipt, etc. It has, of course, failed to prove kidnapping of R.S. Gandhi and realizing rupees 5.4 crores from him. It has not examined, said R.S. Gandhi as a witness, notwithstanding. It has been able to establish other parts beyond all reasonable doubt. In my respectful submission, is a finding again based on no material. Then 426, it is, however, correct. This is significant because we are roped in under section 17. Your lordship says, knowledge is a sine qua non for that offense. 426. It is, however, correct that mere raising and collecting funds will not satisfy all the ingredients of the charges under 17 and 18. one more requirement, that is knowledge, is also necessary. But having considered all the facts and circumstances which the prosecution side has proved against them in totality, it cannot be said that all commissions or omissions have happened without their knowledge. The transaction amounts were always very high. The said amounts were defalcated from government official norms and rules and funds meant for development of NCAC. The same were withdrawn with utter disregard to the official norms and rules and channelized to Kolkata. Under the above circumstances, facts and can it be said, Malad, please mark this, Malad, with respect, Malad, such a finding in my respectful submission could not have been made, Malad, to convict Malad an accused for the offense under 17. Can it be said that all these happened without their knowledge? To our considered opinion, the answer is no.
Yes.
It happened with their connivance and knowledge. Again, no material. The government officers A15 of PHC department and A4 of social welfare department made payments to contractors without supply of material, making the rate of supply more than double the market rate by preparing false bills and vouchers, delivery challans and money bills. I'm again repeating, Malad, this part could not be proved. Rank Hall said, Malad, we have no role in that. It was done in the office itself. And the signatures there could not tally with me.
The amounts went into your accounts, it's a fact.
No, Malad, not from social welfare, all cash. From social welfare department, Malad, no payment came to me.
No payment.
No payment.
No check payment.
No. And that's admitted, Malad, by Rank Hall. Then he said, can it be said that it happened without their knowledge? The contractors have withdrawn huge sum of money from the banks on a given day. Malad, this is that 84 lakhs which was withdrawn. Malad, from Guwahati State Bank of India, Joe Road branch. So what initially the NIA was trying to connect was, to connect it with the Seizure.
That the trial court has recorded finding.
419, it could not be connected. And in fact, there's an observation memo which they had suppressed. That observation memo also said that this money, Malad, could not be connected to the Joe Road branch. The money came from a bank in West Bengal. In West Bengal, the branch is Salboni and Dispur branch. Now let's.
Yes.
Then he said, the contractors have withdrawn huge sum of money from the banks on a given day. Can it be said that they happened without their knowledge? Huge sums of money were converted to US dollars. Again, no material. Can it be said it was normal business? Huge cache of sophisticated arms and equipment were recovered at the instance of the accused. Can it be said to be normal circumstance? The answer to all these circumstances is emphatic no. Therefore, we are inclined to hold that the accused persons have the knowledge that those funds likely to be used by such persons to purchase arms and ammunition. Well, a respectful submission is, Malad, these findings, Malad, the Lordship says does not flow from the evidence on record. These findings, Malad, with respect, Malad, deepest respect are perverse. And in my respectful submission, Malad, could not be justified, Malad, by any stretch of imagination to convict, Malad, the appellants under section 17.
Okay.
Now, let's. Two aspects. Also, Malad, one was, Malad, the Lordship said, one was the issue of the registration of the firms. One allegation is that it did not have valid permits to do business, Malad, in NC Hills Autonomous District Council.
Yes.
Malad, PW 128 Mukut Kemprai, Malad, has said at page 636, volume 3. Where's my volume 3?
Yes. No, all right, you need not read the evidences again.
Lordship may just mark, Malad, page 636, volume 3. Malad, Mukut Kemprai has said, Malad, that all the firms he was instrumental in the registration of the firms, and he said all of them had valid.
Registration is a different thing. License or permit to trade with the councils. That is what the allegation is.
Yeah.
That you have not proved. There is a clear allegation. There are statements of witnesses that their licenses are expired.
In 2008.
Yes.
But Mr. Kemprai says that the licenses were valid under the. Just have a look, man. Just let me read volume 3, page 636.
Read. Exhibit. Judgment. Yes. Yes.
636, cross-examination for accused Devasys Bhattacharya. My lord has it.
Yes.
It is correct that after proper verification, I have issued permits in the names of the 5 firms. It is correct that the above said firms had applied through proper.
What is the date?
Requisite.
You very smartly not asked about the date. Prosecution has come out with a positive allegation that the licenses had expired in 2008. So this cross-examination is misleading as a matter of fact. So this doesn't take you anywhere.
And last 4 lines, whatever.
Yes, we have read that.
It is true that all the firms were genuine and registered.
Genuine, registered, all right. Licensed to do trade with the council.
Yes.
That is what they.
Under the rules, in once the license lapses, then we apply for renewal.
So where is the renewal?
And if the renewal, is delayed, every year you have to keep asking for a renewal, and if renewal is delayed, you pay the penalty. That's all. Now, on the other aspect of registration, your lordships have already seen,
it's not their case that they were not registered.
Yes.
They have come out with a clear case that the firms were not having license to do business. And despite that, the orders were placed.
The permits were
Permits.
Yes, my lord.
So that is what their case is.
No, my lord, I have just read this Kemprai, who said.
Kemprai also says firms permits were issued on 31/1/2008.
Yes,
It could not have been beyond 1 year, your own case.
Yes, my lord.
So then you say that yes, question is, you issued the permit. He says so. Even in chief, where is the question that there was an extension? And further he says, valid up to 31/3/2008. No cross-examination of that.
Yes, my lord.
Valid up to 31/3/2008.
Yes.
No cross-examination on that.
No, and he says, my lord, on the register, last line, the register containing issuance of permit and renewals of permits are not shown to me in the.
All right, what of that? Where is the denial of this fact stated by the witness in chief? That the permits are valid only till 31/3/2008. That was a fact known to you.
Yes, my lord.
Definitely. Witness has said so. Burden now shifts on to you. Explain.
That's the only, whatever was placed, put to him.
Very well.
No, on the other aspect, on registration, your lordships have seen trade license.
Registration is not an issue.
In Guwahati Municipal Corporation, that was a perfunctory inquiry which was done. And insofar as the chief investigating officer is concerned, he himself admitted that it had valid registration, that the firms had valid registration and trade license. So that aspect, because the trial judge, if a lordship have para 6, 279, sorry, 379. It has drawn an adverse inference, 379,
Para 379.
Yes, my lord. 2112 at 2111 at 2112.
Yes.
Circumstance number 15. Exhibit 279 shows that firms Borel, Loknath had no existence in Guwahati and also had no entry in the Guwahati Municipal Corporation. But this, my lords, in fact, was admitted by the investigating officer PW 150. If a lordship just have 794, my lords. Volume 4. 94, volume 4, my lord.
Give it in a brief note. All right.
Yes, ma'am.
Yes.
Yes, I have given. Now, my lord,
What I was trying. Page 230. What I was.
that's it to do. That's it. That's what the annoying to be. Get up. Ali pass it to do. Page here is
Yes.
Look, we had taken out the certified copies, my lords, of the charge sheets, my lords, in the CBI charge sheets, in both the social welfare department case and, my lords,
yes,
the PHE department case. Though, my lord, Jayanta Kumar Ghosh was an accused, my lords, in the FIR. In the charge sheet, your lordships have already noted, he is not an accused.
Yes.
And insofar as the charge sheet, my lords, for,
But these, if you read the charge sheet,
yes, my lord.
these are in relation to different transactions. The charge sheet doesn't deal with the transactions which are subject matter of these allegations.
No, my lord.
Read the charge sheet. We have read the charge sheet. in
Yes, yes,
detail.
my lord.
They are entirely different transactions. Mar trading, there is no reference at all in this charge sheet.
First, my lord, just have page in that page 7, my lords.
Yes.
One second. I'll check the report.
Point out where there is a reference to Mar trading. They are for different projects. The defalcations have been done. This is the investigation. Maybe there might be one more FIR. There are a large number of FIRs.
Yes, my lord.
So this charge sheet, which has been given to us today morning, there is no reference to Mar trading. Come to page 23. There is a reference of 67 lakhs, wherein Mar trading is shown. But the amounts involved in this case are much bigger. Only reference to Mar trading is here. Women welfare.
Your lordship is reading the social welfare.
Women welfare.
Yes.
Yes, 23. Page 23. Child welfare.
23, my lords, paragraph 17.37.
Yes.
Supply orders favoring the above funds were issued by RH Khan, again in so-and-so. Supply orders favoring.
So the amounts involved, Mr. Chaudhary,
are different, yes.
in the present case are different.
Yes.
The transactions are different.
Yes,
So this charge sheet has no effect at all on these allegations. Anyhow, that apart, now taking on record these charge sheets is out of question. They are not excising 391 at this stage.
But my lord, the investigating officer was asked, my lord, about referring this to the CBI.
Yes.
And please see what he says, my lord. Give me page 4.
Yes.
Page 793, my lord, volume 4.
Yes.
It is true.
Page?
Page 793, my lord.
Yes.
Right at the top, my lord. It is true from the last paragraph of the final report of the present case filed under section 170.
Yes. Yes. Yes.
It is true that from the last paragraph of the final report of the present case filed under section 173 of CRPC, I have requested the central government for investigation of the alleged allegation of misappropriation of government funds, criminal misconduct, forgery, etc. by the CBI. After obtaining necessary consent from the state of Assam or investigation by the ACB of Assam Police.
Yes.
I am aware that the CBI has investigated the cases of misappropriation of government funds, criminal misconduct, forgery, etc. in various departments of
So
NCA.
that is the reason, because CBI was to be involved, central government sanctions were to be involved. That is why this part was
So
given
the
to
state government consent was taken by the central government and then it was referred to CBI.
So that is the reason. There is an explanation.
In the last two lines, Mala, it is true that there is no law by which two investigating agencies could investigate the same offense against the same person twice.
We don't need his opinion on that.
Yeah, ma'am.
Yes.
No, Mala, now what the trial court holds, Mala, at para 378.
Yes.
Page 2110.
Yes.
There, of course, remains no doubt that some commission or omission on the part of the investigating agency. It has not investigated the other offences, i.e. defalcation of funds of NCH, he connected to the scheduled offense and handed over the task to the CBI. The learned defense counsel has rightly pointed out this in his argument.
Chaudhary, we have read all this.
And
We pose the question to all defense counsel
yes,
that the language of the charge contains ingredients of all these offenses,
Yes.
fraud, cheating, forgery,
yes, madam.
defalcation.
Yes, madam.
Yet the charges are not framed. In absence thereof, whether these findings could have been recorded. If you have any judgment on that issue, please provide that.
I'll do that.
It's difficult that this judgment will be available, but this is the line of thought on which we are working. That the allegations are there, they have tried to prove the documents, and yet they don't pray for framing of the specific charge.
Specific charge was not framed. Charge
And
was
yet the
restricted to-
trial court records the finding. What would be the effect thereof? Okay. Anything else to say?
No, my lords, one aspect I need to clarify
Yes.
is what PW 94 my lords, Mukherjee said, my lords, AB Mukherjee, that pursuant to the threat
Yes.
which was rendered in Hotel Pragati Manor, he went back and started my lords, clearing the payment.
Yes.
Now, my lords, this is in fact negated, my lords, your lordships take my written submission, lordships have my written submission, my lords.
Yes, we'll read that. Yes.
Just one chart I wanted to just place it, my lords. At page 47, running page 47.
Yes. You already stated this in details.
Yes, my lords.
Yes.
Just, if your lordship sees, my lords, on 26 February 2009, the chart which is there, my lords. From the evidence of KB Mukherjee, it is clear that he became executive engineer Haflong on and from 26 to 2009.
Yes.
That meeting, my lords, in Pragati Manor, your lordship knows, is 20th of March 2009. On the same day, in Exhibit 312, a bill of March rating dated 26/2/09, there is an endorsement by Nikhil Kantanath stating that verification was done and it was found to be correct. This is on 26 February 2009 itself, my lord. Much prior, my lord, to that meeting in Pragati Manor. The said Nikhil Kantanath was examined, and in his examination in chief, he said that the said verification was done under pressure of KB Mukherjee. My lord, then 7309, from the cross-examination of KB
Mr.
Mukherjee.
Chaudhary, these people have destroyed the economy of this area. Don't try to gain our sympathies. It's a different matter that the investigating officer has committed a blunder. Otherwise, these people should never have come out. It's a fact. We have heard you enough. Next council. We'll take note of the written arguments. Yes.
Just one.
Yes. All right.
If your lordships have, my lords, the last circumstance against Sandeep Ghosh, my lord, the principle of agency is roped in by the learned trial judge, my lord. Just have a page para 379.
Of judgment?
Yes, my lord.
Yes.
Page 2115.
Yes, yes, we are having it.
Since the last circumstance, since he is a close associate of accused Jayanta Kumar Ghosh, the acts of these two persons are attributable to him. But this is nothing, my lord, but the law of agency which has been roped in, my lord. That, my lord, I'll just give your lordship the citation, my lord. That has been held, my lord, in fact, in Navjot Sandhu's case, my lord, that this principle, my lord, cannot be stretched this far in a criminal case. That, my lord, is paragraph 103 of Navjot Sandhu.
You mentioned it in your written submissions.
Yes.
We'll take note.
I note the judgment which I have relied upon, my lord, with paragraph and the proposition we're handing over.
Yes. Okay. Very well. Yes, please.
My lord, with all respect, my lord. My lord, that written summary, my lord, we have placed it in Niranjan Hojai. Today, during course of argument, my lord, senior prosecutor friend, my lord, he stated one thing, by reading the evidence of PW 23, my lord, he tried to bring him or say something to the effect that I follow in the ambit of section 20, my lord. But 20, definitely, my lord, that evidence of 23, my lord, PW 23, that does not make him progress further, my lord. Nothing to do as regards membership. But, my lord, section 20 is to be read together with section 15, my lord, with all respect, my lord. Reading conjointly, my lord. Independently doing it would do a lot of harm to both prosecution and defense, my lord. So this is my lord summary we have placed before your lordships for your lordship's kind perusal, my lord. With all respect, my lord.
Thank you.
Well, as far as the argument canvassed, extensive argument has been canvassed from both the sides. My lord, I'm not going into much more on these things. I would like to have as respect to Joel Garlosa, what the prosecution was that they relied upon the evidence of 3 witnesses. Dilip Nonisia, Langthasa, saying that act, their deposition attracts the riders of section 15 of Terrorist Act. With all due respect, my lord, I have taken your lordship's consideration on those judgments of Nalini's, where it has been clearly explicited that what will constitute a terrorist act, and terrorist act can be constituted only if the mens rea mental element is there, and in the charge that has to be reflected. Failing which no charge can be framed under terrorist act, and conviction is least concern, because mens rea and actus reus has to be there. Now, my lord, with respect to the financing, terror financing, which your lordship has put the query, that though there was no charges, explicit charges with respect to deflection or under the IPC offenses, though they were—
It's not deflection, it is defalcation.
Defalcation and siphoning of government fund. My lord, my argument is that the investigating officer who has been examined, who exhibited the charge sheet, he has categorically stated that this particular set of evidences were to be looked at by the CBI. And in examination, he has said that because the government is central government sanction is there. Be that so, my lord. My argument is that even when the investigating agency has said that this particular set of evidence will be looked by the another agency, CBI. Now, from where does the trial court can draw inference from the evidences at the framing of charge to frame a charge under section 17? Because section 17, my lord, is a distinct charge under the UAP Act, and those charges are there also distinct charges in respect to other offenses, IPC. If it would have been investigated, then it's fine. But since it is not investigated, bringing up the content of those charges, it is not sustainable. And that is why, my lord, your lordship said we cannot get a direct judgment. But for that, if you refer to Hitender's judgment, my lord, which I have referred on my last occasion. Yes, Hitender, Vishnu Thakur. The Honorable Apex Court has extensively dealt and said that at the time of framing of charge, the trial court should not act as a mere post office, should take part in it, because the implication of framing of the charge will have a serious implication on the trial itself.
Yes.
Because, like my lord, for example, Chapter 4 and 6 of the UAP Act, any person is charged of that offenses, his right to bail gets in a
You
sense
already
forfeited.
said so, you already said so.
So, my lord, that is not sustainable. And my lord, with all this, my lord, I humbly praise that this appeal must succeed. And one more aspect is that this judgment itself is perverse, because there is no evidences to bring us in the dragnet of any of the panel provisions. And perverse, my lord, I have got a judgment. I have placed it in my brief note, my lord.
All right.
Okay.
How's Mr. Mishra doing now?
He is to undergo his colonoscopy tomorrow, madam.
Okay.
He is to be admitted tomorrow morning.
Okay.
So far as he requested me to list 2 provisions of the Assam Autonomous District Constitution of District Councils Act. Rule 28(1) and 31(1), madam.
Yes. 28(1).
Page 8, my lord.
Yes.
28(1) says the executive functions of the district council shall be vested in the executive committee, my lord. And then I'll place my lord 31(1), my lord. That each member of the executive committee shall be entrusted with specific subjects. The allocation of the subjects being made by the chief executive member. During the relevant time, Mohit Hojai was the CEM. The defalcation is pertaining to two departments, PHE,
Social welfare
and
and
social
PHE,
welfare
yes.
department. During this period, my lord, two EMs, my lord, Hamjanan Langthasa, as spelled out by PW 44, and one Nipolal Hojai. He was of social welfare. Hamjanan Langthasa.
They were the
was
executive
of
members.
PHA department. So I was not concerned with them. So any amount of check or amount cash was delivered, it could not have been without the knowledge of these EMs. And these EMs, the NI has not made them a.
They are the witnesses.
Nepal
Nepal
is
is a
a
witness.
witness. Sir. One of them is a.
Yes.
Okay. And so far as my lord, there was another saying that PW 51 and 53, there were sometimes small time contractors, they were given checks and asked to withdraw the money from the bank and give in cash to Mohit Hojai. My lord, Mohit Hojai was the CM. He's like a chief minister of a small place. No person can just go and give him the money. Like what they have said, my lord, PW 51 and 53.
You know, the saying is money talks. So you don't know to what extent a man can go for money.
His place is highly guarded place. It cannot be.
That's all conjectural kind of.
That much speculation.
Okay. Yes. Note karna kaun.
Regarding Mahmood Kemprai, my lord, I am giving a written submission, my lord. I'll already made my argument.
You made extensive arguments, yes. Mr. Kumar, you have anything to say?
Nothing but.
Nothing to say?
Yeah, I'll say this much, my lord. We have given a memorandum of written argument, my lord, as per provision of law. And we'll leave a copy to them also for necessary verification, my lord. We'll take into consideration that. And so far, one Vanlanchana is concerned, my lord, only some typographical things are there, my lord. We'll do it by tomorrow. We'll much over.
All done?
All done, my lord.
Okay, thank you.
Much over, my lord.
Arguments have been heard. Judgment is reserved. Very much.
It's nice to get a patient hearing.
You know, see, they got near two, my lord. What? That other case?
There's another part, two.
Another case, we have already decided to separate it. We have recorded it in the hot sheet. We'll hear it separately.
Separate.
Yes.
That will be, it will be off the time.
After this, we have already ordered that will be separate. I'll pass an order here in this one. Today we'll pass the order to detach those appeals and themselves.
Because evidence of that near one was taken in near two. my lord.
Same.
It's already placed. Yes. Okay.
Much obliged.
Much.